I tried to talk to Mr. Zandy's legal aid. The only thing I'm looking for, the only reason we're here is to get that subpoena for the records from our marital counselor. It was key in the GAL's decision of what went on. So we're just trying to clear that up and get that so we can totally find out what was actually said by that counselor. That's the only thing we're here for. Everything else can take its time. Mr. Zandy?
Your response to that, Judge?
Yeah, I saw there was a motion to compel, and I reviewed that. And I reviewed the response. I didn't.
They got the video, so that was one motion to compel. The other one was finances, and Megan saying she wants more time with that. Sounds like the only other thing is that at this moment is the subpoena. Megan said to the guardian ad litem to Ann Height that that counselor had kicked us out of counseling because of my actions, and made decisions based on those things and other things that that counselor supposedly said, but they were never verified. So we're trying to get those records. That's all we're doing.
So in response to this, I really don't know what it is he's after, what he's doing. Behind the scenes, we're trying to give him and accommodate him what he's asking for via email. There's never been a formal request for discovery. There's never been interrogatories exchanged. I'm not sure about the subpoena. I didn't see that, or I think in his materials that he provided for today. There's been no CR26I conferences. There's been no formal request whatsoever made by Mr. Hitchcock or through his prior counsel. We're really concerned at this point. Like, this is getting out of hand. This is now the second time we've been here in 3 weeks for motions that frankly didn't have a legal or a factual basis to be brought. We tried to kind of insinuate in our response that this is improperly before the court, that you don't ask the court for a subpoena. You have to go through the appropriate routes of discovery. Yet here we are. I do understand that Mr. Hitchcock did have a conversation with my legal assistant this morning. I've been made aware of that. The docket this morning never got over for me until about 12:30 or so. So I'm trying to, again, gather what information I can, but we were just here 2 weeks ago on a request by Mr. Hitchcock to rescind a restraining order. The court readily dismissed that, only to be then served around the same period of time with this motion to compel discovery that I still have really no idea what it is he's asking for. Again,
Your Honor, why are we here?
Mr. Hitchcock, you always interrupt. Nobody interrupts you. So please don't interrupt anyone else. Go ahead, Mr. Zandy.
So again, I mean, from a procedural standpoint, none of this is appropriate, but this is now fourth time we've been in court. Largely to Mr. Hitchcock's doing, and my client quite literally is going backwards on the fees. So we are asking for a contribution, and then again, just kind of a strong message that this isn't appropriate. This is borderline abusive at this point.
Your Honor, can I speak now?
Well, no one else is talking, so yes, you can.
Your Honor, these claims were made to the guardian ad litem. They were primarily the reasons why I'm on supervised visits. I've spent over $5,000 in supervised visits. I've lost over 100 days with my kids. I don't know why we're here. Chad could have emailed, or sorry, Mr. Zandy could have emailed motions to compel. I mean, they could have been answered. I said that this morning. I said, all we need is, we just need to agree on this, on getting the facts of what the counselor said. If the counselor said what Megan said, then that makes sense of, what's going on. But if the counselor did not, which is what I attest, I mean, this entire case, my supervised visits, the $5,000 I've spent, the trauma it's caused my children, it's all in naught. And it's all been pushed by what I believe is clearly lies. I know that the counselor didn't kick us out because of that. Megan stormed out of the session. Megan stormed out of the last session, and then she blamed it all on me. And then Ann just believed her. I believe Ann's here, but this hasn't been justice. These kids are suffering because of these lies. Megan has repeatedly lied. We know that. We've seen that. And these kids, we're
here on Mr. Hitchcock's motion and docket notice for a motion to compel. That's why we're here. And all this is well beyond the scope of discovery issues.
Mr. Zandy, either you're covering for your client. There's no reason why you wouldn't.
Okay,
want this
so
forward.
I'm done right now. So a couple different things. If you were involved in this treatment, then you should be able to access the records yourself. If it was marriage counseling between the two of you and you were both there, then those records are just equally as yours as they are hers. So you should be able to access those directly from whatever that counselor is. I'm still talking. Secondly, this isn't the proper format to do this. You can't compel someone to produce something when you haven't formally asked them to give you that stuff. Mr. Zandy is indicating that has not happened in this case. So it's really prematurely before the court to compel them to do something when you haven't formally asked them to do it outside of the purview of the court. So those are the two responses I have. I understand the frustration that you may have. I understand the frustration Mr. Zandy may have with this case. It's always kind of, every time that you're before me, Mr. Hitchcock, it's everybody else's issue but your own. I understand you're frustrated. I sympathize with that.
Your Honor, Megan lied.
But I'm still talking, Mr. Hitchcock. I don't know that she lied. So I'm taking your word instead of somebody else's, and we have a neutral third party that looked into all of this. And, that's where we came out. I don't think I was involved in that portion of your case. I've only been dealing with the last couple months of your case, but at this point, I'm going to deny your request. If you make a proper request for that information and are unable to get it, then you're in a position where you can move to compel that information to be provided. But the onus isn't on Mr. Zandy or Ms. Hitchcock to provide that if it's records you can get yourself. And if it's mutual counseling, then you're both have equal rights to those records.
The counselor denied me getting them.
That makes zero sense whatsoever. I don't know if Ms. Height would be able to discuss that because their ROIs were all entered, it appears, based on my review of the GAL report. So I'm denying your request. As for a request of the petition or fees to the petitioner, or excuse me, to the respondent, they're asking for $2,000 in fees. I almost feel like I should grant that because we're here for a lot of things. And I understand that you're not an attorney, but you're held to the same standard as an attorney when you're representing yourself. And we're here on things that we shouldn't be here on. So I'm not gonna grant $2,000. I'll grant $500 in attorney's fees.
Once again, if Mr. Zandy would have emailed me and talked to me.
Great. You keep working with him on that. But that's
technically the main compel I'm here for is to compel Megan's wages from over 2 years ago. That was the actual
thing you just told me is the only thing we're here for is the records from the counseling. And now all of a sudden you're talking about compelling records for finances. Have you asked and done a formal request for those through Mr. Zandy? And
you said last time we were here that was officially, asked for in the initial asking.
Okay. Well, then we're done with what we're here for. All right. So I'm going to deny your request. I'm going to impose $500 in attorney's fees.
You want to set a presentation date?
If you'd like,
a bench order.
I can do a bench order. That's fine. I'll just make a note myself.
Thank you.
And I believe Ms. Turnbull was able to make it on.
Yes.
Okay,
I'm here. Thank you.
And so this was before the court, I believe 2 weeks ago, when Commissioner Nelson was covering your docket. He set a review for mother's visitation to determine how we go forward. If you look at the bench order, don't have it directly in front of me, but he subsequently entered a bench order, provided that mother needed to submit a clean hair follicle test by the end of March. I confirmed with Ms. Turnbull prior to this hearing that we haven't received any drug testing for mother whatsoever. My client has voiced some concerns to me. The mother is showing up to visitation under the influence of substances. So absent a test consistent with the court's order, I would be asking the court to suspend visitation until we get that drug test. We potentially could set another review to ensure that visitation isn't indefinitely suspended, but we do have concerns about the child's safety.
And is Miss Aldrich present today? Do not see that name or hear a response. So, and forgive me, Miss Gilmore. So the hair follicle was not done at this point, or has not been done at this point. Okay. Then based on your representation, I feel like that is probably the appropriate way to move forward. So I'll suspend any visitation pending the outcome of that hair follicle, if and when she chooses to take it.
Do you want me to submit an order ex parte, or do you want to draft a bench order?
If you could do a short order ex parte, I will
Called
sign it
my
as soon as I
office
receive it.
earlier today.
All
It was
right,
over
thank
the
you.
noon hour. He indicated he had lost his documentation as far as the Zoom feed. And so I emailed him the Zoom information, but I don't see him on my end.
All right, is there Sterling McCoy present?
Your Honor, this is the clerk. Just so you're aware, I got an email at 1:11 saying he was trying to log on.
Okay, thank you very much. Sterling McCoy, if you're present, if you're on a telephone, *6 to unmute. And just for the record, I have nobody in the waiting room.
Yes, can you hear me?
I can hear you. Can you tell me your name,
Okay.
please?
Yeah, Sterling McCoy.
All right, thank you.
So, Your Honor, I'm sorry.
No, go ahead.
We're here on my client's request, her motion to waive the mandatory settlement conference requirement pursuant to the local court rules. As you can see, there's currently pending felony charges that Mr. McCoy has, wherein my client is the victim of those actions involving both stalking and violating of a protection order. I have previously attempted to communicate with Mr. McCoy in regards to settling the case. He has not provided any meaningful response. We are continuing to receive discovery requests. We just completed our 5th discovery answers. So we're on the point of, or on the cusp of, asking for relief if there are further discovery requests coming. But in my estimation of the case, I believe that sufficient discovery has been exchanged and received on both sides. And my client is simply concerned that Mr. McCoy is not going to participate in that process in good faith, given the fact that he hasn't responded in good faith to settlement negotiation attempts outside of a mandatory settlement conference process. I think his reply declaration even supports that, or even further supports that conclusion when he says he perceives that the MSC process is going to allow him to, quote, identify the areas of disagreement and reasons for such disagreement, unquote. Certainly he can provide that information to me so that we can see if we can't work those things out. So simply at this point, we're asking to waive that MSC process and allow us to proceed to trial.
Yes, Your Honor. All I'm asking for is, this is really confusing for me as I'm not an attorney, I'm representing myself, but I'm asking for specific account numbers for 2 different accounts that I was actually listed on, and that was the purpose of my meeting with her on Thursday, as I responded in an email to her, and I have tried my very best to point these specific credit cards out. I'm coming up with a $26,000 discrepancy. And it reflects the amount of cash that we had in a safe. Is why I want these specific accounts. And other than that, I'm looking at trying to come up with a fair and equitable, exchange in the end. I really want this to be done. I don't think it's unreasonable. It's just that we had the CR26I conference scheduled for Thursday, and that's the only thing I wanted to go over with her, just very briefly. That specifically a couple different accounts that we got sent, but there was there's no way I can get into the credit cards because with my Social Security number or the last 4 digits of the account number, it's not allowing me to get the information I need. Other than that, I'm working on an end to this.
Okay, so it sounds like there's 2 different issues that you have.
Yeah, well, my wife is also claiming that her mother gives her money each month for attorney fees, gas, groceries, et cetera, and I have no way of knowing this.
So what we're here for, Mr. McCoy, is essentially a request to strike the mandatory settlement conference. And it sounds like you're talking about discovery issues. So they're two separate issues. And if you have a CR26I set for later this week, that's great. Hopefully those discovery issues will be resolved. As for the motion, and I'm assuming you did, Ms. McLean, did you submit an order?
I did, Your Honor.
I'm going to grant the request to strike the settlement conference based on the local court rule and the pending charges. If you could provide it again, I would greatly appreciate it.
Sure, I'll do that.
All right. All right. And
Caitlin Ernest here for Jaden Edgel.
thank you. And I believe I saw Miss Looney here. Yes. Okay.
Hey, President, we're just here involved as to child support at this time, so I'm just observing today.
All right. Perfect. Thank you. All right. I have reviewed. Sorry, I'm just looking. I have reviewed. We're looking at a contempt and then a request for some temporary orders. The contempt is based on the Friday morning visitation. I think at Head Start is, and I'm kind of breaking it down to brass tacks here, and the missing days there. I am happy to hear from, and I've reviewed all that. I've also reviewed the parenting plan requests. So,
Your Honor, did you receive the objections I filed late yesterday?
no.
I didn't think you would, but I wanted to get them into the record. I have a variety of objections, procedural things to request of the court prior to us going into arguments.
And why should I hear those on last minute notice with nothing before me?
A lot of them are pertaining to the declarations that I was served with late pleadings on early morning of the 12th. They're mostly objections related to the evidence that has been submitted by Mr. Walker.
And Your Honor, if I may, it says under the Cowlitz County Local Court Rule that if there's good cause, my uncle died that day. And so I got them in the next morning. It's written into my declaration, which was also filed, pertaining to the evidence. The court can weight the evidence. They're talking about text messages between the parties. I submitted the declaration of how I access those messages. The court can give whatever weight they want to it. Authenticities for the court to determine. The rule states that if it shows two different people, if you can reasonably ascertain who is talking, and if they're parties to the action, that it's authenticated, and essentially it's up to the court to decide whether or not they give any weight to it or whether or not they toss those. And so I'd ask that they be in, and I think good cause, the fact that a very, very close family member of mine died that evening, and I immediately had them filed at 8:30 the next morning, as soon as the court opened, and Miss the opposing counsel was also served in the morning that morning. I think is good cause. And additionally, one more thing. Additionally, to prejudice her because it's our response. It's the end of the process. It's our motion, so it's our response. It doesn't limit her time to respond because there is no time to respond.
Your Honor, Mr. Walker's rebuttal pleadings are far beyond the four-page collective rule for local rule. Those were some of my objections. I think each rebuttal declaration is 5 pages plus. Each has at least 50 pages of exhibits attached to it. So cumulative, we're looking at hundreds of pages of exhibits that were filed as part of this. And we're objecting to the inclusion of all but the 4 pages of those rebuttal declarations.
Okay. I'll note that. That'll be noted. Let's move forward.
Your Honor, I'll start with the contempt because I think that's kind of the easier one to go through. The court ordered on September 21st that the father was supposed to have Friday and Saturday visitation on a different schedule. One was at Head Start. Head Start, since September 21st, when it was entered until the end of February, when we originally cited this, over 20 days were missed, 20 different visitations. The majority of those were at Head Start. There were some Saturdays. Every time it was the same excuse: child sick, child sick, child sick. The fact is that we then discovered that mother had missed the bus so many times and not canceled the bus that the bus system threw her off the bus. So now mom is saying, I don't have transportation. I don't have transportation. The fact is that the reason mom doesn't have transportation is mom's own actions. Dad has tried to get makeup time. They keep offering him the same time period where dad can't do it on a Sunday. This is the thing. The makeup time is not anymore. The makeup time is tacking an extra hour on here and there. It would take a year to do that. This is mom. This is essentially mom doing this. Mom could have brought the child to Head Start. Mom says, well, the child had a runny nose. Head Start won't allow that. Well, that's clearly not the case. Head Start, we submitted things on how Head Start goes about determining whether or not the child can go. Runny nose is not a symptom there. You also see for the mom's own discovery, she said the child's not sick. Child hasn't been to the doctor in a really long time. So she can't have it both ways. She can't give the discovery saying child hasn't been sick, which we've submitted as an exhibit, and then say child's been too sick. You'll see everybody and their mother is offering to come pick up this child. You'll see in the text messages, and child's too sick to do that. But really it's a transportation issue, according to mom, when somebody else asks her. So this is clearly contempt. It's a willful violation. She could have done anything. My client is willing to do anything to see his child. The fact is adding an extra hour here and there is not working. So I guess going into that, moving directly into the parenting plan, I believe would be appropriate, given that they kind of, what your honor decides today, will kind of determine what makeup time. So if I have your honor's permission, I'll just jump right into the parenting plan.
Sure.
Okay. Your honor, when this was originally cited, there was no evidence. There was really no evidence. It was a he said, she said case. That's no longer where we're at. Mother originally said that there was a rape here. GAL didn't believe her. We now have the text messages that clearly show that these two 14-year-olds unfortunately decided to have a baby, made that conscious decision and did go forward and have a baby. And that's where we're at. You'll see that there's a lot, essentially everything mother said in her original declaration can be proved to be lack credibility with the text messages. Number one, there's no rape. We can see mom is clearly asking him over and over again to get her pregnant. We can also see that mom does drink and does use drugs. And we see that at Exhibit C in the original declaration where mom is talking about smoking weed. We see that in her discovery where she says she only quit on March 23rd of this year. We see her drinking on her TikTok. That's a problem. That's a problem because mom is, although she's 16 now, she is the one responsible for this child. Her mother is extremely disabled, as we've seen. So really, it's on this young girl to become the parent. She has a drug and alcohol problem. She's lied, made false statements to the court about rape. She's also withheld the child. You'll see at Exhibit A that the child's always sick. She has every reason under the sun to not have the father have the child. She says in a text message to dad, well, you're dating this other girl. You're never going to see your child. That's a problem. We also have a Mr. Doug Perry, that's the stepfather of my client, who's been essentially excluded from this child's life, which means my client can't really have visitation. He's reliant on his stepdad. And the reason for this is they say that he text messaged his niece something sexual when he was intoxicated, and that means he can't be around this little girl. We've submitted a polygraph to your honor showing he is not interested, a psychosexual polygraph, not interested in children. His niece is 34 years old. And there's really no reason to have this. But what it does do is make my client have to have his visitation in his vehicle with his mother because they have other children that are in the house. Mr. Perry is there. And essentially they can't go to church. That's why they can't have a Sunday visitation because he's there. We have provided a number of text messages because it shows. These are texts taken at the time. They show that she is not credible. They show that he is credible. They show that the abuse that was happening was her to him, not the other way around. My client has literally done everything here. He's gone through parenting class. He's taken a hair follicle to show that he's negative. He has gotten his driver's license. He's insured. He's gone through anger management, and he has a GPA above a 3.5. We have done everything here for him to be able to have more visitation with this child. He's also paid, and this is one thing that we really want. He's paid for a hair follicle for her at Performance Occupation with an alcohol ETG. It's already paid for. It's ready for her to go. He will even pay her taxi fare to go and take that. She's saying, no, I need to go through my general GP. I've never heard that before. A UA is very easy to pass, requires something to drink. It makes sense for her to take this. It's already paid for. So, Your Honor, we'd ask that visitation change. My client be the primary until the GAL comes forward with his report, given all of this, that you enter our parenting plan, you essentially get rid of the restrictions on Doug Perry. It makes it impossible for these people to have visitation, for it to be supervised. My client doesn't need to be supervised. This is a kid that has a 3.5 GPA, that has a job, that's doing everything he can. There's a bad actor here. There's somebody that's not credible, and it's absolutely not my client. We'd ask that our parenting plan be entered. We'd ask that the bench order against Doug Perry be lifted. We'd ask that my client be allowed to have unsupervised with this child. That's how he's going to learn to be a father, is to take care of his child We'd ask that she take the hair follicle. We'd also ask for a mental health evaluation, but I'm sure we can wait for the GAL on that. Thank you.
And I ask either party here, when that order was entered with regards to Doug Perry? Even just a general, how many months ago?
I believe, I want to say September 21st, but maybe I'm wrong. I don't
It
actually have
is
that far back.
October 13th. Oh, no, it is September 21st.
Of 22.
Yes, Your Honor.
Your Honor, we have something that was filed October 13th of 2022.
And that's my client, Your Honor. So October 13th, I think is probably the more accurate. I think it was ordered on the 21st and the order actually got entered on the 13th.
So I see the order. Looks like there was an order entered. Actually, I don't see, do I see the order? Yes, an order that was entered, signed by Commissioner Nelson on September 21st. I have no context for the Mr. Perry's. I don't know what this text message was. I didn't go that far back in the case. Can anyone point me to any
Yes, Your
index
Honor.
that may have that information?
In the declaration filed by Jaden on the 28th of September, it includes her declaration plus the messages between Doug Perry and the niece.
So the declaration was after the ruling?
So what happened was it was an issue that was raised during a hearing. We didn't have enough information at the time. The court preliminarily said we're going to halt visits where Doug is present, and then they gave us some additional time to file a declaration with that evidence. And then that's what we did on on October 12th at that hearing.
Okay, so I see the declaration affidavit, and I see that it indicates that those messages were filed under seal, and I have an order sealing the documents. So could it be the October 11th sealed records? Thank you. Ms. Ernest, you want to respond now?
Yes, thank you, Your Honor. I first want to talk about why we are here today. We are here today on the motions and declarations of Mr. Walker that can be only described as attempts to harass, intimidate, and control my client. He is using this court as an extension of his abuse toward my client. There's no question that Ms. Edgell, my client, is a victim of domestic violence. There is a finding in this court record. 0-08. Mr. Walker filed 14 pleadings, and my client submitted 2 and had a live witness at the testimony. Despite all of those declarations on behalf of Mr. Walker, the court still found that he committed domestic violence against my client. That finding is in the record, whether Mr. Walker likes it or not. And those are the basis for the supervised visitations at this point. Mr. Walker's abusive behavior was then litigated at the fact-finding hearing, in which you can hear Mr. Walker calling Michael Popper dumbass fuck and a bunch of other really horrific things. Commissioner Nelson specifically asked Mr. Walker about that video, and to which Mr. Walker didn't have much of a response other than, yes, it's true. Then Commissioner Nelson included in his ruling that the court condemns these statements in the stances under which they are justified. Mr. Walker can accuse my client of lying, attack her credibility, that he is a credible threat to my client, and that he committed domestic violence against her. What we're seeing here today is on par. It's textbook behavior for what people who are abusive do in court systems. So now moving on to the contempt, we're asking that the court deny the motion for contempt. First of all, there are several visits that have already been discussed and taken care of in previous hearings. Specifically the September 23rd visit, the October 21st visit, the November 11th visit, and the November 14th visits were all addressed during a November 16th hearing. This is not the first time that Mr. Walker has brought a motion for contempt for a visitation that was already addressed. On July 5th of last year, Mr. Walker filed a motion for contempt in the protection order case that alleged my client missed a visit on June 11th, when my client had already been held in contempt for that visit. Walker's tendency to be overly litigious. So second, my client has consistently offered makeup time. She is not lying when she says that the Head Start has turned away her child when the child has the running. We submitted to the court, which I know Ms. Winkles objected to, more records that show the policies of Head Start that we believe should be included in that complete document. Children are turned away for runny noses and a variety of other things. And it doesn't mean necessarily that the child is sick. There's been no bad acts here, no bad faith. Client has been turned away from Head Start, and I've tried as her attorney to organize. If the court will allow it, I can call in and hope for better reception.
If you want to call in, that's perfectly
I
fine.
don't have any other way of, I don't know what's going on with me.
Exactly what the court didn't hear. To summarize what I've said so far, we're asking the court to deny the motion for contempt. My client is not lying when she says that she's been turned away from Head Start because the child has a runny nose. There have been times that she's taken the child to Head Start and she can't get in because the child has a runny nose. That is consistent with their policies, which as we submitted to the court, and I know that Ms. Winkles objected to them being admitted into the record, but we believe that they're necessary to complete a complete piece of evidence that shows accurately what those policies are. My client has consistently offered to make up time. She does not want to rob Mr. Walker of any of the time that he has owed with his child. It has been difficult with the protection order in place. And, you know, we have been trying our best now that there is another attorney involved. There was a switch in attorneys. It was all very confusing. There was a lack of communication, and my client is simply doing the best that she can with the circumstances that she is experiencing. Mr. Walker claims that the missed visits are somehow retaliatory. The truth is that we have continually tried to make up time. They're not retaliatory in any way, shape, or form. There's no bad faith on my client's part. She is a teenager. She is doing the best that she can. She doesn't have a driver's license. She does not have reliable transportation. Anything from Mr. Walker saying otherwise is purely speculation. She's trying to graduate school while raising an infant. She is really, truly doing the best that she can. So there is no bad faith on my client's part, and she should not be held in contempt. So moving on to the temporary parenting plan, the standard is, my understanding is that the standard is that Mr. Walker needs to show a substantial change in circumstances. I don't believe that he has showed that here today. Since this since this parenting plan was put in place, there have been no changes. He is pulling up messages from before my client was pregnant, during her pregnancy. They're years old at this point. Those do not establish a change in circumstances. The child is happy. The child is growing, developing. She's thriving. She's healthy. And she has been and will be in my client's primary care. The evidence that Mr. Walker has submitted, the abundance of messages from an undisclosed service that his attorney used to download these from somewhere, they all attack my client's credibility, but that is an issue that should be reserved for trial. We are not here making a finding about my client's credibility. That should be reserved for a time when we have the opportunity to direct examine, cross-examine, and sort of really tackle that head on rather than in a temporary order. My client is not perfect. Nobody's perfect. Mr. Walker is not perfect. Individuals who have experienced domestic violence often exhibit behaviors that appear to be irrational. And that is a quote from an appellate case in matter of RV. My client is traumatized and she's terrified of Mr. Walker because of his actions against her. Regarding Doug Perry, this was an issue that was brought before Commissioner Nelson, and he readily told my client that anybody that thought that this shouldn't have been brought up was wrong. He thanked her, not necessarily thanked her, but he was open and willing and receptive to this being brought before the court, and he was ready to make that finding that Doug Perry could not be around the child. As far as we're concerned, there's been no change in circumstances for that either. The polygraph test, we never said that he was a child molester. We never said that he was going to prey on the child. What we're saying is that his behavior was extremely predatory and inappropriate. moving along, there's a lot to cover here. The drug allegations. So Mr. Walker, who has been found to have committed domestic violence against my client, filed his declaration demanding that she go get a hair follicle test. So as a victim of his domestic violence, she doesn't want to do that. What she will do, and what she's told me that she will do, is work with her doctor. And we believe that that is the most appropriate avenue here. Mr. Walker cannot establish or prove that there is a long-term impairment resulting from drug or alcohol use that interferes with my client's ability to parent. He's not even saying that. He's just saying that it's a teenager who's smoking weed, and she needs to have a hair follicle test. An unverified photo does not mean that my client should be subjected to the invasion of a hair follicle test. Really, this belongs with her primary care physician. She's not denying anything at this point. So the hair follicle test really wouldn't provide any information that the court doesn't already know. There's no basis for any change or limitations on my client. Like I said before, the child is happy, healthy, developing at an appropriate pace. Being turned away from Head Start due to their own policies is not a basis to draw conclusions that the child is regularly sick and should be therefore removed from her mother's custody. Continually accusing my client of lying and attacking her credibility, specifically as it relates to the rape allegation that has already been litigated, that at this point is moot. We lost that. We're not pursuing anything more with it. We're trying to move forward and create a parenting plan that works for everybody. Continuing to relitigate this and calling my client all sorts of names is just, again, further abuse that is used to control my client. So with that, Your Honor, we would ask that the court not only deny the motion for contempt, but also deny the requested changes by Mr. Walker.
Brief reply, Your Honor.
Yes.
Just to hit Doug Perry. The court had a text message. That's it. The court based a restriction on a text message. Now what the court has is a polygraph exam. The court also has more information that that text message was sent to a 34-year-old woman. This is not sent to a child. There's a polygraph that clearly shows he's not attracted to children. That in itself is enough to remove a basis to restrain an individual who's a stepfather who lives in the same house as my client. What that does is it means that my client doesn't get a full family visitation. My client's a 16-year-old little boy who had a child and who now has to be a man and who needs the guidance of other men in his life. The fact that Mr. Perry made a drunken mistake and texted an adult, somebody well over the age of majority, was gross, frankly, but not enough to keep him away from his granddaughter, especially with the polygraph there. Additionally, we have more information now. That's what these temporary orders are all about. They're essentially fact-finding and giving the court more information over time. What we have is we have the initial finding of DV against my client for using bad language. We also have my client going to anger management. We have my client going to parenting classes. We have my client taking healthy relationship classes as well. There were no texts available at that time, minus what was submitted by Mrs. We now have me essentially downloading his entire phone and giving the court really good information about the fact that, and no one knew this, when these temporary orders were entered, these two decided to have a child. The fact that they're saying there's no long-term impairment through alcohol and marijuana use, I would argue a 14-year-old girl that has a very severely disabled mother that has no transportation, no driver's license, to have a child at 14, I'd say there's an impairment there. The fact is that this is not used to humiliate or harass anyone. This is used to put the child in the best possible circumstances to give this child the best possible outcome. We have a girl who was 14 who drinks, who smokes marijuana according to her own testimony, who can't take the bus anymore because she got kicked off of it, whose child can't go to school now because she can't go to school because she was kicked off a bus. We have a girl that lives with a severely disabled person or has moved, according to the discovery that we have, to an unknown location. We have text messages, essentially with her being abusive as well. We have all of this, or we have the dad who made a mistake, went to anger management, took parenting classes, has a 3.5 GPA, lives in a stable home with his mother, has reliable transportation, a driver's license, has like I said, a 3.5 GPA. The best possible place for this child and the best interest of the child is with the most stable parent, and that is my client. The fact is that everything here that we've put forward to the court is not to harass her. It's to show that she wasn't credible to start with, That's a problem going forward. We don't know if she's going to be credible about what is happening with this child. The fact is, it's a child that cannot protect themselves. Sharon Walker, who is my client's mother in the GAL in this, is the stable influence in this child's life. The mother does not have that influence. She doesn't have that sphere of support. She has a lot of things going against her that we hope she remedies. We hope she is sober. We hope she does get a driver's license. We hope she goes back to school. We hope she can get back on that bus. We hope all of these things. But the fact is that dad is the best possible place for this child. Dad has done everything this court has asked for and more. Dad is the one with the evidence. Mom has merely a self-serving declaration. Also, you'll see from the text, mom's reasons for terminating the visitation or stopping it change as the day changes. Either the child's sick or they've turned her away or she doesn't have transportation. Dad, on the other hand, will facilitate mom's visitation. He does have transportation. His family has transportation. His mom is there, his stepdad, and his biological father, Kevin, who has provided transportation to this parties on a number of times when the parties were speaking. So, Your Honor, we'd ask that the parenting plan be entered as we've asked. We ask that Doug Perry no longer be restrained from this child. It makes no sense. We'd ask that dad not have supervised, because if mom doesn't have supervised, and you've seen the text where mom tells him she's going to kill herself, she's going to kill him, she's going to have him beaten up, he better be afraid. All of these things, really, these are two, excuse my language, dumb 14-year-olds making a baby. But the best possible thing is to put that child now in a very stable situation. And that's with my client. Thank you.
All right, thank you. Mr. Lawrence, I don't know if you're here just for this case or if you, I don't know if you're still in the middle of doing a report. Your interim report is many, many months old, so I don't know where we're at with you.
Yeah, I haven't finished a final report yet, Your Honor. This is a case where the shoes just never stop dropping. I'm extremely frustrated. You have a situation here where both parties are alleging that they're adult enough to raise a child, but yet when they have issues, then they try to rely on that they're only a teenager and therefore should be cut some slack. I'm really frustrated that these two cannot seem to get their act together. And Mr. Walker, through no fault of his own, ends up with a stepdad that gets into a sexual jackpot that ends up creating a stir. Ms. Edgell basically engineered what she terms was a rape where the child was born. I'm getting really frustrated that this childish behavior can't just settle in and look at the best interests of the child and to establish a parenting plan and both parties stick with it. Sometimes GALs joke about how they have a case where maybe neither parent is worthy of that child. And this is kind of one of those cases. And in my estimation, whatever parenting plan is ordered, there should be strict adherence to that. And if they can't seem to resolve it, then maybe CPS should get involved to remove the child. Because quite frankly, that child doesn't deserve all of this immaturity and backing and forthing on this thing. They need to grow up and realize what they're dealing with. This is not some game that they're playing. This is a child. And right now, I think Mr. Walker is probably the better parent between the two from what I've seen. And I would support Ms. Winkle's proposed plan at this point. I have not completed my investigation on this, but I think it eliminates a lot of the name calling and all of the hearings because she can't seem to follow through. I know I don't normally get upset in a case like this, but there's just too much of this going on with these two, and it needs to stop. And I apologize if I'm out of line on this, but that's the way I feel on this matter, Your Honor, and that ends my testimony.
Thank you, Mr. Lawrence. Do you have a time frame for a final report?
I can finish up in 30 days if these guys will settle in.
Okay. Thank you, Mr. Lawrence. Here's where the court's at this point. This is a extremely frustrating case. When I read it, my first thought was, what a mess. Kids having kids, and the drama. There's just so much drama that's associated with this, and I don't think either party understand the implications of some of the things that they're throwing around here, not to mention the impacts that this could have on a child that they, for whatever reason, decided to conceive when they were as young as they are. We obviously cannot go backwards. We can only go forwards on this. And here's the frustrating part. I understand Head Start has their list of reasons for why a child can't be there. If mom's missing the bus, that's mom's fault. If mom's kicked off the bus, that's mom's fault. If mom doesn't get there on time for the visitations to happen, that's mom's fault. There's no sympathy anymore for, I'm a teenager. You chose to have this as your responsibility and to conceive this child. If you're the primary parent, you need to be where you need to be when you need to be there, period. We can excuse occasional incidences of the child not being accepted at Head Start based on a runny nose, whatever. But that isn't all the time. And it's not on dad to have to then rely on makeup time. That's ridiculous. And it's not going to stand any longer. So here's what we're going to do. I'm going to order the hair follicle test by mom. That needs to happen by the end of this week. I am going to order both parties to complete whatever they need to complete with Mr. Lawrence and get on board with finishing up whatever they need to finish with him so we can have this report. I'm going to reserve on the parenting plan, and we're going to come back on May 16th at 1:00. Actually, let's do the 23rd. That way everybody gets the report and has an opportunity to review the report from Mr. Lawrence. And then Mr. Lawrence, if you could, if you're going to be delayed, if you could just let the attorneys and myself know. By that point, we should have the hair follicle. We should have the final GAL report, and I will consider a change in the parenting plan potentially at that point in time. I understand Ms. Ernest's position about adequate cause and a change in circumstances. I think potentially, arguably we have that, arguably we don't have that here, depending on how things kind of fall into place. Secondly, so as far as the contempt, I'm going to make a finding in contempt. She needs to be where she needs to be and can't just assume that every time that she misses something that it can just be made up and that's okay. That's not okay. So I am going to make a finding of contempt on the missed visitation. Frankly, I don't know if the parties care this much. I hope we don't have to be this pithy with each other, but if I need to go through and mark which days I'm not finding contempt based on, and which days I am, I will do that and get it to the parties as soon as I can. But I think based on my review of the records, there's sufficient days that she just wasn't there or used an excuse about why she couldn't be there. So I am going to make a finding in contempt that was a willful violation. The child should not, moving forward, be used as a pawn by either party to get what they want or try to influence the other person. I reviewed the messages from Mr. Perry, and it's frustrating to me that happened. And I'm not going to suggest that anything Mr. Perry did was appropriate or shouldn't have been considered by this court. But I also am not going to continue to let that be a detriment to the father in this case, who has done a whole bunch of things and progressed to try to take responsibility for the situation he now finds himself in. So I know that there was a discussion about Sunday visitation starting. I'm gonna allow for that in the meantime if the parents agree to that. And I'm going to essentially lift the conditions around Mr. Perry as long as another parent is present. So like, it sounds like they would be going to church, stepdad, mom, and Mr. Walker. So as long as another party is present, Mr. Perry can be around the child moving forward. So it's not a complete removal of that condition, but someone else needs to be present. That way it doesn't limit Mr. Walker completely. The remainder of any decisions will be set to the 23rd of May at 1:00. If there's any presentation that needs to be set prior to that, by all means. I think May 2nd is closed and next Tuesday is closed, but I also have Fridays at 8:45. Otherwise, we can enter the orders on May 23rd.
Good afternoon, Your Honor.
All right, so this is a motion to modify the temporary order and parenting plan.
Correct.
All right, go ahead, counsel.
All right, very good. For the record, I'm Chelsea Baldwin. I represent Jonathan Rance. This is our motion to essentially modify the current temporary order and move to a regular parenting plan. I do think the procedural history in this case is important. My client at this point has been doing reunification counseling for more than a year. But when you look at that procedural history, it does inform sort of what has happened and what is continuing to happen. My client was released in the very late summer, sort of early fall of 2021, sort of got his ducks in a row, made sure he was ready to start reunification. And filed for reunification in November of 2021. And from there, Mrs. began sort of delaying the case. We see the court finally ordering reunification December 13th of 2021. The court set an outside review of February of 2022 to make sure that that had started. When we get to court in February, no progress had been made, not even an appointment scheduled at that point. The court essentially said, all right, we'll come back in March, make sure that you've actually begun. At that point, we come back in March of 2022. She still had not even set an appointment to begin reunification counseling. At that point, the court essentially orders that she schedule an appointment within the next week. Essentially, your feet are now absolutely to the fire. From there, reunification counseling finally starts to begin, but you see that she continues to frustrate and delay the process. In June, she's held in contempt for withholding information about the child. June, again, there's a separate order that requires her to provide specific information about the child that she's withholding. In July, we're compelling. There's an order to compel because, again, she's withholding information. August, she faces sanctions for continuing to faces and as receive sanctions from the court for continuing to withhold information. So again, there is just a very long history of obstruction, withholding, and attempting to alienate the father from the child. In this case, the court-appointed reunification counselor was Charlotte Rosen. We have provided her letter for you as part of the materials. She is the court-ordered professional. Her letter details essentially 10 months worth. She's continuing to work with the family of her work with them. She talks about the fact that essentially about 5 months in, around sort of mid to late summer, this is kind of a tween, preteen child. He's kind of done with this reunification thing and is ready to move on. And from there, there's no issues reported by anyone. So Charlotte Rosen talks about, I checked in with mom, I checked in with dad, I checked in with other people. Nobody reports any issues. They move forward to hybrid visits where the visit starts in her office, then father and child go off somewhere. That visit sort of ends in her office. Again, no issues, no problems. Those go great. She checks in with mother. There's no issues. Mother agrees. They move forward to having 8-hour visits. So now we're having longer visits. Again, she details in her report, I check in with mother, I check in with father, I check in with third parties that are on the mother's side. These are sort of mother's interested people. No one reports any issues, any concerns. So at that point, Ms. Rosen moves forward saying, okay, it's time to begin overnights. We have this great overnight opportunity for the child where he was going to go snowboarding. Grandparents on my client side were along. So sort of all the safety factors are completely in place. No one has any issues. Everything's all approved, child told. And then mom says, oh, I found out I don't have to do this. So no. Go back to 2-hour supervised in-office appointments, even though that's not what we've been doing for months, even though there are no reported problems or concerns. It's just, no, I don't have to do this. So I'm going to do something that's detrimental to the child. There was nothing that had changed. There was no event that had sparked that request. It was just, I don't have to, so I'm not going to. And even though, again, we're months down the road, this was just her desire. So at that same time, my client expresses interest in going to the child's events, his sporting events, his school events. Mom says, no, you can't show up to those. If you even show up to, a basketball game or football game, well, gee, that's a violation of the order. So you can't even do those basic things. So again, that alienation, that control, and we have that continuing pattern of withholding. Where we are today is we're now still stuck in 2-hour fully supervised visits that the reunification counselor says are not appropriate. They haven't been appropriate for months and months and months now. And I'll relate to the court, some deep concerns about the timing of sort of when those visits were ripped back. But I think it's important that we talk about the respondent mother's sort of statements of concern and where she says, oh, these are the reasons why, we shouldn't move forward. We shouldn't progress. We shouldn't have even gotten to where the trained professional said we should be. And the reality is all the concerns she relates and reports are essentially 5+ years old. They are extremely old. And there is no new issue that she's reporting that has a current concern. First, she says there's no connection, that there's no bond. Again, Ms. Rosen's report directly contradicts that, says dad and child doing great, had a pretty quick reunification. They were doing really well, continue to do well, that they're relating well together. It's notable that my client recounts that while he was incarcerated, he tried to call the child, would send the child letters, but mom was, again, so focused on breaking that bond and withholding that she said if he continued to do that, she would seek a restraining order against him and try to get this court specifically to get a restraining order against him if he even sent a letter to the child. Even if she could open it first, even if it was fully appropriate, if you even send a letter, I'm going to get a restraining order, which was really critical. My client was involved in a very low supervision facility. He was part of a firefighting program, part of a facility where essentially the restriction is so low that he could have walked out the front door. Like there really wasn't, there's a gate, but it's not locked. Was the type of facility he was at. And again, being allowed to go out on the wildline fire lines, and all of that would have been ripped away by that restraining order because it would have meant a change in his status. So again, my client could even send to child letters based on mother, but my client continued to write letters. He just sent them to my office, and we provided the court with a smattering. We didn't give you all of them because that would be too much. But again, they're all appropriate. They're all reasonable. They're all child focused. Mother's focused on breaking that bond. But again, that bond exists now. They've been in reunification counseling at this point for a year. It's ridiculous to say they aren't fully bonded. The next issue she raises, oh, he's a rampant drug user. But again, let's go back and look at the evidence. The evidence is that from day one, she's had the power to drug test my client. The only time she requested a drug test was at the initial hearing. And when it came back clean, she refused to pay, even though it's a loser pays type situation. So again, the single time she's asked for that, she has not asked for a single hair follicle since that time. So again, she's not concerned. She's, oh, he was driving high. She should have had him tested. But again, he wasn't. And my client provides for you a clean hair follicle currently that shows that he wasn't. So even if you were to believe, sort of her fears, those hair follicles go back 3 months. So again, not an issue. Was never driving high with the child. That simply did not happen. And there's no evidence to support that. And even she didn't think that happened because she didn't ask for the hair follicle. I'll note that it's important for the court to remember that my client in October or November of last year had major surgery. That surgery required prescription pain medication. My client got off of that as soon as he rationally could, because again, he didn't want to be on that because of his history. And now we have, again, that proof of sustained sobriety because we have that proof of now he's 3 months clean. And again, he had a surgery where it was required, it had anesthesia, significant issues, but again, he's clean. So that does show his commitment to sobriety. Next, she claims, oh, well, he's at the vape shops. That proves he's doing things. No, you can smoke tobacco, you can vape, you can use things that are legal. He doesn't even have THC in his system. So again, that current hair follicle and the prior hair follicle show he's not using anything at all. She next says, well, make him, even though I've not asked for a hair follicle, this entire case, except for the first get-go, make him have to do them quarterly. And so if he has to do them quarterly, that's about $600 per year. So she doesn't want to pay it. And she just instead wants the court to make him have to pay it. My client's fine with maintaining the loser pays language. But again, now what she's doing is she's putting the onus on my client to provide the $600 essential product or he loses his visitation. Again, she hasn't had that concern. It's not reasonable that the court implement something like that. Perfectly happy to have the loser pays drug testing language to be maintained. Next is he has a violent past. My client cannot change what has already happened. From day one, after that crime was committed, he owned it. He pled guilty for it. He did his time. He used his time while he was incarcerated to take advantage of essentially every program they had. He did parenting classes, took sobriety classes. He did the wildland firefighting program. He supervised others in that program. So again, we're in a situation where he did everything he was supposed to do and used that time productively to turn his life around. And he's essentially been very honest with the court that sort of that period of time saved his life and put him back on the right path. So he's owned that from day one. But since that day, many years ago, there's nothing that's happened since. There is no indication, no concern, no text message, no email, no letter. There is no nothing that would indicate any concerns that he has continued anything along the lines of violence. So again, learned his lesson and has done everything possible to show the court as such. We are asking the court to adopt our parenting plan. This is a young, sort of again, tween, preteen. He's ready to move on with his dad. This is life. He's ready to get on with it. My client is more than willing and ready to get on with it. And this is what Ms. Rosen has recommended for a long and extended time at this point. Our plan is where we should be. It's essentially It's essentially moving forward to regular visitation, which is appropriate. If the court wants to do some sort of ramp up, that should be extremely fast, like over the period of a single month. Like we're going to do overnight visits for 2 weeks, and then we're going to move on into regular weekend visits. I'll note that we are asking for fees in this matter. This is an instance where this is bad faith. Again, and that's where that history comes into effect and where we have to think about the fact of how the respondent mother has drug her feet for extended periods of time. And at this point, I would argue it's caused financial harm to my client, but also to practical harm to the child, in forcing him to be in reunification counseling, essentially in a small room where you're stuck there for 2 hours and you can't do anything. That's ridiculous, especially when my client had moved to a point where they were doing entire days with no one reporting any type of an issue. The timing of this is important. Again, I relayed to the court, my client had an injury that was an on-the-job injury that he had. He had major surgery that put him on L&I. That means his income was substantially reduced. That's very close. Shortly thereafter is the time where mom says, yeah, we're going to yank back those visits. It happens within the next month or two. So again, real concerns is, oh, well, you can't pay to get back into court. So now we're going to use that to withhold and try to move everything back. We have no one voicing any concerns, no one reporting any problems, everybody reporting that things are going well and appropriate. And mom just says, no, I'm going to take you back to 2 hours, fully supervised, sitting in a tiny office, because that's what I want. That's bad faith. That's not in the child's best interest. And I think everyone here can relate that it's not in the child's best interest. We're asking the court for $3,500 in fees and costs. That $3,500 is considering not only my fees for this motion, but also the fact that these parties and my client specifically has paid substantially for reunification and counseling. It really isn't needed anymore. We're way past that. And we were past that months and months ago. We were progressing to a point that was reasonable where we were ready to move off anything to do with Ms. Rosen until mom sort of pulled this latest thing out. So we're asking for $3,500. I think that is reasonable in this instance. So again, we're asking the court to adopt our plan, allow this child to move forward, allow my client to move forward. That is in the best interest of the child.
Thank you. Ms. Jeffers?
Your Honor, I'm just going to start with a clarification of a couple of issues. Father likes to take advantage of the fact that mother was unrepresented for a long time. Her income is $700 a month. Since I took over representation, there hasn't been any issues. And as far as who's alienated the child from the father's own actions did that. It's not mother can't take responsibility for the crimes he committed or the incarceration. He is extremely assaultive, and quite frankly, father says, oh, there's no text messages or phone calls since I was convicted, but that's not true. The reason that communication was terminated was because of the abusive nature of the phone calls by father. Mother's requesting that you adopt her parenting plan, which is certainly not in bad faith. It is consistent with a recommendation of the GAL. Father likes to only take consideration of himself when it comes to this case. Mother's trying to take consideration of the child. She's also asking for an award of attorney fees. The problem is that since we filed our parenting plan, that father's provided evidence that he's taking generic Adderall that, to her understanding, is not recommended for prior meth addicts, meth being the drug that he was on when he committed the crimes against him. If you look at the hair follicle test, you can see that he's testing positive for amphetamines. And quite frankly, Adderall can be abused and lead to continued addiction. It seems to also be that he is taking that on a regular basis, which alone can be a basis for a DUI. And he's been driving the child around apparently on it. Father does have significant 191 factors. This is undisputed that he has felony assault convictions. He doesn't put that in his parenting plan. Obviously, that's true, but he says, no, it's not. He obviously has long-term problem with substance abuse and now is taking a legalized form of amphetamines, quite frankly. He says, look, mother is a drug addict, but the reality of the situation is that all of her tests are clean. She has never had an issue. She doesn't have any arrest history. None of that. Mother is also, and with regard to requesting hair follicle tests are very expensive, especially when you are pretty much solely supporting a child on $700 a month. Mother also alleges that he abandoned the child, he's neglected his duties, that he has engaged in significant domestic violence when it comes to her, including the threatening calls that he used to make from jail, that he uses an abusive use of conflict. You know, what's strange here, Your Honor, again, is the concentration should be on the child, where the child's comfort level is. And all father has done throughout this entire case, if you read through his declarations, are attack mother again and again and again. They have a phenomenal son, and she is the person that has raised him. Father has no credibility before this court. He outright lied in his declaration and said he's been clean for 8 years, but he was only arrested 5.5 years ago while he was under the influence, and we submitted that information. Again, he says mother used to have a substance abuse issue, but there's absolutely no evidence of that. He lied to the reunification counselor when he represented that the court said she was to determine visitation. That was not true. That was just a bullying technique against mother to try to make her feel like she must agree to everything that he was asking, quite frankly. And even as he just spoke, he said, oh, they're having 8-hour visits. I'm looking at the information from the counselor saying they had 4-hour visits. He is not honest with this court at all. And that is concerning to mother. In the past, he's never been able to maintain sobriety, and he's not sober now. He's on prescription amphetamines instead of regular methamphetamines. There have been multiple purchases at his old head shop. This is something he doesn't even deny. And he admits that he was on major narcotics for surgery, which is an issue for someone in recovery. And these are all issues that anyone with a young child would be concerned about. And that is mother's main concern, is the physical and emotional safety of this child. He's a great kid. He's a sensitive kid. He, is a people pleaser. And father has taken advantage of that, quite frankly. Mother denies hindering father's visitation. Again, what she's asking for now is supported by the recommendation of the GAL. And, she just asked that father be sober. I'm not sure how to address this issue in that he isn't. He submitted a hair follicle test showing that he is not sober at this point. Again, both parties have been subject to motions to compel. The counselor says reunification counseling has been regular. Again, the issue with the reunification counselor is that she has okayed father driving with no checks to make sure he was sober. And now we know that he was not. He lied to her about her role and used her to basically strong arm mother into things that made her uncomfortable. And father has a history of this behavior. The child has suffered as a result of this behavior. Father has been putting a lot of pressure on the child since he's had unsupervised visitation. The child fears standing up for himself with dad.
So I'm going to object. That's not anywhere in the record. So it's not in Ms. Rosen's report that there's any sort of fear expressed by the child. The child's been pressured. That's just not anywhere in the record.
It's in mother's declaration, just
That
as
would
you.
be hearsay with no evidence otherwise and no foundation.
All right, that's noted. Go ahead, Ms. Jeffers.
Your Honor, father has never been the primary parent of this child. The child didn't even know who he was until 17 months ago. And the child has only known father for the last 10 months. Yet father wants the court to pretend he's been like a normal father all along. And that's just not true. Father has attempted to interfere in relationships where the child has had a good male role model. And quite frankly, father disparages mother to the child, comparing homes, even though he lives with his mother. In the 18 months since his release, he's been unable to obtain his own housing or hold down a job. And that certainly isn't a sign of progress on his part. He's still living off others and unemployable. Even father's own stepfather into the GAL seemed to express discomfort with father's interactions with his younger brothers who are closer to the child's age. Mother is proposing a step-up visitation consistent with the GAL recommendation once father is sober that puts the child's interest above that of either of the parents. She really wants father to maintain sobriety, to include prescription medication. And mother also requests $1,500 in attorney fees. There is a gross disparity of income between the parties. Based on the child support worksheets, his is about $2,000, I believe. Hers was $700. Father paid no child support for over 5 years, leaving mother with the full financial burden of raising this child. It is father's own actions why we are here, not mother's. Mother had to pay 50% of the reunification costs, even though father is the one that got himself thrown in prison, and even given the disparity of incomes. Mother paid significant fees when father took advantage of the fact that she was unrepresented and pro se. Mother requests that you adopt her parenting plan and award $1,500 in attorney fees. Thank you, Your Honor.
Thank you, Ms. Jeffers.
Yes. Well, first, counsel's wrong when she says that they were only on 4-hour visits. If you look at page 2 of Rosen's report, third paragraph, it's clear that they were already on 8-hour visits. So again, that's just an absolute misstatement of what Rosen's report says. Number 2, there's no history of assaultive behavior since my client's criminal conviction. There's no proof of these calls ever being threatening. Again, the letters that we've provided show that my client was more than appropriate. This idea that you can have a DUI with Adderall, no, not at 10 milligrams. And again, it's ridiculous that counsel's now trying to be a physician and act as if a physician cannot prescribe appropriate medication. That is a low dose for Adderall for an adult. So again, not appropriate. 191 factors. Again, my client does not have any DV assaultive history. It was a stranger. That was, again, many years ago. So that's not appropriate. This idea, during my client's surgery, I'll clarify, he did not use narcotics other than the anesthesia. He used nerve blocks to avoid having any narcotics, any opiates at any time. So just so we're 100% clear, my client wanted to not impact his sobriety whatsoever. He's been completely clean and sober. The Adderall does not impact that. My client was the primary parent per an Oregon court order. So again, we do have a history of my client being the primary parent. My client also maintained a job for approximately a year before he was injured on the job to such an extent that he had to have major surgery. So again, this idea that he's unstable, simply not true. And again, where we know that they are exhibiting bad faith is that their own current proposed parenting plan is offering an 8-hour visit, and yet they've ratcheted back to a 2-hour visit. And until we're here today, really aren't offering anything more. So this idea that they've ripped my client back to 2 hours, but now say, oh, well, we'll give him 8. That doesn't make any sense. Then why have we placed my client at 2 hours when even you admit it should be a minimum of 8? So I was in the court, it's time to move on. Again, their acts do exhibit bad faith. Fees and costs are appropriate. My client's on L&I. She's fully supported by a third party. Fees and costs are appropriate.
All right. I just went back and looked quickly at the Ms. Corey's GAL report and recommendations, and I'm reviewed a large chunk of this case. I understand the frustrations of the parties, and I understand both arguments. I know that mom's position as dad willfully removed himself from their life based on his actions and then incarceration. I also understand that dad's trying to do everything he can to make up for that time and be present in the child's life moving forward. I reviewed Ms. Rosen's report a couple different times, and looking at that coupled with Ms. Corey's report, which isn't about 4 months old at this point. I think it was filed in December. So relatively new information. And frankly, I don't know if everything from that report was addressed by the court after the report was filed, because it also indicates that mom should be have a drug and alcohol evaluation and whatnot. So I don't know if that's happened yet. I'm not looking to go there, but clearly there's a lot going on here. Ms. Rosen is the professional. I think we're all very aware of how many cases she's been involved in. And Ms. Corey's report essentially defers to the reunification counselor and what kind of structure should be provided moving forward. And the proposed plan by mom, contingent on dad being sober, a hair follicle every 3 months, alternating Saturdays after 6 visits, alternating weekends after 6 successful weekends. And that's weekend, Saturday to Sunday, after 6 successful visits, alternating full weekends. So Friday to Sunday. And I don't think either party's proposal is too out of line. Here's what Ms. Rosen indicated, that she wants to see the child hooked up with a regular counselor. Is that something that has been done at this point, or is he still just seeing Ms. Rosen?
Just Ms. Rosen, Your Honor.
Okay. Here's what I'm going to do. I'm working off Ms. Baldwin's parenting plan. I understand that the previous temporary parenting plan had a whole list of 191s that were involved. This parenting plan doesn't list any. I don't think that we can just omit those other findings, and some of them were reserved for trial. So I'm going to keep the 191 findings in place that were made initially. I am going to work towards, so we're going to change things to joint at this point. What I'd like to do is, we've been away from 8-hour, or I guess full day visits between dad and child for a handful of months now. Is that fair? So what I'd like to see is, let's do 2 full day Saturdays.
Yeah. Is that per the counselor's recommendation, 10 a.m. to 7 p.m.?
If everybody agrees with that, that's fine with me. I don't care about timing.
And as would be 9 to 7, if that's all right. I mean, if my client, he doesn't live locally, he lives south, that just gives sort of a more regular day. If it's a Saturday, that doesn't impact school.
Well, and I generally would not disagree, but he is a tween who likes to sleep in on his weekends too. So 10 a.m. seems appropriate. It's a longer visit than father's ever had with him.
The recommendation is 10 to 7, even in Miss Baldwin's parenting plan. So we'll keep 10 to 7. So I want 3 full days. So 3 full Saturdays of visitation.
Are those going to be sequential? So essentially every Saturday for 3 Saturdays?
Barring any pre-made plans mom may already have had. Yes, that would be ideal. And then I'd like to switch then to every first, third, and 5th weekend, Saturday, 10 a.m., Sunday, 7 p.m. I want to do that for 6 weeks. And if there's no issues, then it'll be the same weekends, 1st, 3rd, and 5th, Friday at 5 to Sunday at 7. Ideally, if there can be a check-in with Miss Rosen at some point during this process, just so that child, I would assume, is comfortable with Miss Rosen at this point and would hopefully express any concerns that they may have with her. Or if there's a pursuit of another counselor that, that process be started. But I'd like Miss Rosen to at least check in on this case for another month or 2. So we have somebody that has some history. So if just the child meets with her, maybe once or twice over the next 3 months.
And Your Honor, if there are issues, should the child report that to her? I'm not sure what to do if there's a problem.
If there's a problem, hopefully, yes, there would be an appointment made and he could get in and talk to Miss Rosen. And then obviously if there's a concern, I can always bring it back before the court. Needless to say, Ms. Baldwin, I think I marked up your proposed order a little too much to use it. So
I do want to address though, is the court ordering any summertime, any additional time to be used this year?
And Your Honor, my concern with that obviously is we haven't even got through an overnight visit. So maybe it would be more appropriate that we come back.
I'm not at this point, no. However, after we get through a few actual weekends, Friday to Sunday, if we still have some summer left, which we should, I'd be happy to reconsider at that time if things are going well.
Okay. And then similarly with holidays. So mother's proposed parenting plan had 0 holidays for father. I don't think that's appropriate. Holidays are important. Some of the holidays, for example, Father's Day are important, though my client should have Father's Day this year. My client should have the 4th of July. Those are opportunities to build memories and do those important bonding things.
I will. So Memorial Day weekend, I'm just thinking of the upcoming, I'm not making, if that's dad's weekend, great. If it's not, not including Mondays for holidays to dad's weekend at this point. Mom should get Mother's Day. And so even if that's just a return home, if that's dad's weekend, maybe he returns home, the child home by 10 a.m. that day instead of 7. Dad should get Father's Day. Ms. Jeffers, does your client have any strong position about 4th of July and evening visitation for dad on that day?
I haven't talked to her about that, Your Honor. I mean, her concern is sobriety, obviously.
Well, here's the deal. I'm willing to give 4th of July to dad, as assuming that nobody has any dire concerns about that. I understand the sobriety. Dad should maintain the sobriety. I'm not real concerned about the prescription Adderall that he's taking, especially in the dose that he's taking, as long as that's under the orders of a medical doctor. If there are any concerns with sobriety, that can be raised at a later time. Labor Day, if it's dad's weekend, great, just doesn't include the Monday.
And I'm okay to come back and address 3-day weekends sort of towards the July, beginning of August, kind of as you indicated. July 4th is kind of like the first one that's fairly close that we should address, but the rest of them I'm more inclined to let those lie for now, and with the court specifically allowing us to address those later in the summer.
I agree, Your Honor. And just to clarify, what are you looking for July 4th? I mean, is that a day visit?
I would ask that it be wherever he's at. So if he's at the, you sort of said these 8-hour visits or 9-hour visits from here, and then these are overnights from here, whatever he's at, we'll just make that the same July 4th visit.
I disagree. That wouldn't give him 2 overnights for a 4th of July visit.
It would be he could have, for example, July 4th at 9 a.m. to July 5th at noon or something like that. July 4th is generally evening holiday. So to say return kid at 6, it's like, well, you didn't really get the 4th of July then.
And Your Honor, father's going to continue to provide transportation. Is that correct?
And that we need to address.
Okay, as far as 4th of July is concerned, let's do, it is an evening holiday, it is a date. Let's do noon on 4th of July to dad until 10 a.m. on the 5th. Math wise, we should be at overnights by then. If something stymies that, then obviously that is based on him being at overnights at that point. If he's not at overnights at that point, then that wouldn't apply. Okay, so then transportation, let's address that.
So my client has provided 100% of the transportation for more than a year now. That's not appropriate. It's appropriate that both parties at this point engage in transportation. So we're asking the court to just move to the standard pick up to begin your time. That's appropriate. If mom wants to choose a location up here, that's fine. Certainly have no objection to that. My client can do the same near his location if she doesn't want to pick up at his house. But if my client's providing 100% of the transportation, then there needs to be a substantial transportation credit given to him in child support. It's a one or the other. The statute's pretty clear. So we're asking at this point just to move to both parties picking up. They are both arguably low income. My client's counsel says he's unemployable. His most recent history is L&I due to a substantial injury. So they're both sort of in the same position.
And Your Honor, I disagree. The child has lived in this area for a significant amount of time. Father has made no effort to move towards this area. He's living in Lake Oswego, and mother doesn't provide transportation. She relies on third parties to do that. So that's a pretty big ask. We would ask that for the time being, father continue to provide transportation. If the court thinks that mother should provide some, then I would ask that she get to choose whether it's drop off or pick up.
That counsel's statement is not the legal standard. This child's lived here for a long time is not the basis of child support in that decision. The support aspect is the financial aspect is laid out in the statute, and that is if one parent provides all the transportation, you have to provide a credit for that in the child support worksheet. Child support is currently $304 per month. So again, the idea that she would choose which she does is kind of messy. I don't like it just for that reason. Is there's a lack of clarity there on who's obligated. If the court wants to obligate my client, that's fine, but then he should have a credit.
And Your Honor, a motion for a modified child support is not before the court.
I understand that. Okay, so for the day visits, Dad's gonna be responsible for pickup and drop off. Once we move to weekends, I am gonna share that requirement. My hope would be there'd be agreement to meet somewhere in the middle, if at all possible, if not. And I will allow, sorry, I can't, Miss Jeffers' client, Miss Vick, to choose whether she wants to be the pickup or the drop off on her end. So I expect Miss Jeffers and Miss Baldwin to hopefully have a discussion about that, and whatever Miss Vick chooses, I'll go with.
Okay, so she's going to choose prior to presentation, and then we'll just set it at that. Is that your order? Okay.
Yep.
I do want to clarify. Counsel's repeatedly said that the Adderall makes him not clean, and it's prescribed. The person doesn't have a concern. I just want to be 100% crystal clear that if he has prescription drugs, but they're prescribed, that does not count as a dirty UA or hair follicle, and that's not going to negate his visit.
As long as if it's a prescribed medication that he's taking as directed by his doctor, then no.
Great.
Yeah, obviously if he gets prescribed things that he's not supposed to be driving on, then, we're obviously in a different situation, but I would hope that he would just follow the directives of his physician.
Great. Yep. Also, I want to clarify again, the ability of my client to go to the child's games, sport practices, school events, that my client has authorization to do all of those things.
Ms. Jeffers, you didn't touch base on that any.
I didn't, Your Honor. My client doesn't have any contact with the father due to prior abuse. So that is that's always been her main concern. I mean, I believe that the request has been that he not approach her, those types of things, and he's not willing to comply. So that's where we are on that.
That's never been a request. It's just, you cannot go. My client has no desire to approach her or be with her. He just wants to be able to go to his child's events.
I'm going to authorize that, but I'm going to ask that Mr. Rance not have any interactions with mom or try to avoid any. And then if there is a requirement for some interaction, that they be polite, neither party say anything disparaging or about the case, and the child is what should be the focus. But and I don't know if I'm assuming there's some kind of an app or website that will allow dad to gain access to what activities are happening without having to go through mom. So
Yeah, he has access.
Okay. All right.
And then similarly, authorization to be able to access, him and child can communicate via text and calls, video chats as desired.
And well, Your Honor, I would just ask that before he have free reign access to the child, we get a little bit further into the process to make sure everything's going okay. Certainly there have been concerns that father is highly manipulating the child, and mother has concerns about the amount of pressure that's being put on him. So, I mean, this is a guy he met 10 months ago.
So I'm not reserving on that. When overnight start, that'll be, I'll allow some phone communication. I'm not going to dictate how much or how often, but it needs to be reasonable. And frankly, if mom wants to review what those messages are about and there's any concerns, then that can be brought before the court. So father should be appropriate in these messages and should have nothing to do with visitations, time with him, unless they're planning some upcoming activity. But it shouldn't really have anything to do with the case before the court.
And then is the court generally adopting my proposed section 14? Those are sort of the boilerplate, other play nice provisions. I think the only thing, this does include a prohibition against using corporal punishment. Requires communication by our family wizard, which the parties have already been doing for an extended period of time at this point. And it does include hair follicle provisions, UA testing provisions. In this case, because there are concerns both ways, it does allow both parties to test each other.
I didn't have any problems with those, but
I do. It puts a lot of, like, father's already hooked into the school as far as being able to get all the material that's sent to parents, but this puts a burden on mother to, she is obligated to provide copies of everything from the school that father already has access to. I don't think that that's appropriate. If father has access to the information, mother should be under no obligation. I'm just looking through them real quick, Your Honor.
Our only issue with that is there's a lot of things that get sent home that just aren't otherwise online. What's online is grades and attendance, what's missing in your grade book. But it might not be a notice for a disciplinary notice, might not be available.
Those are online now, at least at the school that he's currently attending.
School photo packets and simple things like that. Homecoming, things that just aren't going to be online.
He's 11.
Middle
No
school.
homecoming.
Yeah, I'm not gonna adopt that portion at this point.
Okay.
And yeah, Your Honor, I guess that when we come back for presentation, I'll look at those, and if I have an objection, we should be able to review those very quickly.
Okay. Do you want to set that date now, or do you want to work together to set it?
No, we should set it.
So the next normal day is the 9th, unless Ms. Wade tells me otherwise.
And I would like to go to the 9th, Your Honor, at this point.
I'm fine with the 9th, so long as the visits as ordered begin immediately.
And I would just have to confer with my client. In other words, I don't know if they have plans for this weekend, but it should start with, if not this weekend, the following weekend. I can agree to that.
Well, and that was part of my order, that they should start as soon as possible, as long as there's not already. And that doesn't mean, just so we're clear, that does not mean that mom can go make plans today for this weekend. That's not, we're talking about long-standing plans before today. Otherwise, it should start as soon as possible. It sounds like everybody agrees to that.
Thank you, Your Honor.
Does the 9th work for you, Ms. Baldwin?
It does, thank you.
Okay. All right, so we'll set presentation. Thank you for your
Tuesday the
patience.
9th.
And I have reviewed everything that has been filed in this case. I do have a preliminary question, and I'm happy to wait until the parties begin. But there was, I'll wait. I'll try not to forget. There was a couple references in some of the documents to two things that I didn't see elsewhere. And so I thought maybe I was missing something, but hopefully that'll be resolved with hearing from counsel. So Ms. Green, I'll turn it over to you.
Thank you, Your Honor.
So initially, both parties represented themselves and had filed initial temporary orders. Mrs. Ellis filed, set a hearing. Mr. Ellis responded, filed his own motion, and set it to be heard with less than 3 weeks' notice. So when Ms. Ellis hired me, I thought it would be easier to reassign it to the attorney docket and hear a new motion. So I'm not relying on any of the pleadings that Ms. Ellis previously provided prior to council. So I did not submit those as bench copies for review either. So I'm relying on the materials that have been presented only since my appearance in this matter, and that's what I'm relying on for our arguments today. So my client has been the primary homemaker, stay-at-home mother for the children. This is a 24-year marriage. My client married Mr. Ellis right out of high school. They've had 5 children together, ranging in age between 2 and 14 years old. And Mr. Ellis has been the primary breadwinner and provider for the home. My client is asking to have exclusive use of the residence, to have a restraining order to prevent him from coming to the home, harassing, intimidating, or causing any harm to her and the children, as well as a parenting plan that provides supervised visitation, given some of the abusive and both emotionally and physically actions against the children and my client. My client has provided a pretty historic account of only a portion of the things that she's encountered with him, with the children and herself, and during their marriage. Some of the important ones that I think matter is an ongoing financial control and financial abuse. My client accounts repeatedly of her husband's controlling all bank accounts, controlling her access to funds, giving her an allowance of $100, $130 per week for expenses, for food for the children, $130 per month for clothing and other necessities for the children, and basically managing every penny that she was allowed to use throughout the marriage, including taking over her own separate bank account she had when she was younger, and controlling every bit of money that she brought into the home when she did work prior to the children's birth. Mr. Ellis brings up the ability of my client to work. That historically has not happened. You can look at the tax returns provided showing that the preschool that he purports that she can make money at earned under, I think it was $700 net income last year, or I'm sorry, he provided 2020, 2021 tax returns. And so 2021 didn't have any income. 2020 had a $700 net income from that preschool. And an additional job that my client had was a sewing job that she made minimal, if anything. So my client has been reliant on Mr. Ellis to provide support for the household since their separation in October, and then again, a separation in December because of conflict over who would have exclusive use of the house. Mr. Ellis has basically established an amount that she is allowed to spend and taken all the rest of the joint funds and put them to a separate account. So my client has basically been fearful of even using the joint account because if you look at Mr. Ellis's accounting of the financials, he states how much he's provided to my client and how much she's indirectly earned from using the bank accounts or using expenses to pay for her household expenses. He's basically halved all the expenses and given her what he purports as half his check, but is not sufficient to meet her needs or the children's needs at this time. He has been out of the household for several months now. I believe it's been 4, and has a room that he is staying at. We don't have any information on the costs because he fails to provide anything in his financial declaration of what his actual expenses are. Instead, he's asking for a monthly budget equal to what my client needs to maintain the household for her and the children to reside with all their expenses. So given that brief history, and I'm sorry, I don't really want to go into the more severe physical altercations. If you've reviewed everything, I don't really want anybody to have to relive those experiences, but it is a pretty substantial history of abuse of the children and my client. And so it is important for the court to realize that a restraining order is more than appropriate to prevent any more anger outbursts and any more attempts to intimidate and harass and abuse the children and my client. So given that, my client has requested a parenting plan that provides supervised visitation for father. We're not asking for a professional supervisor, but we do think it's important for the visitation to be supervised by an agreed third party. It could be a church member or somebody else. Just given that the contact in the last few months especially has been very direct and it seems manipulative with the children, telling them or trying to encourage them to pick dates and times that they'll see dad, and other information gathering from my client's household that is concerning. And so given that my client did not want to restrict time completely for father. Father's had a pretty open schedule to have visitation, but it's very contrary to what he's requesting. He's very inconsistent with his schedules. He's very inconsistent with when and if and who he will take with him for his visitations. And so that's why we're asking for a set schedule of Wednesdays and Fridays for the 2 hours and Sundays every other week after church for him to spend time, which provides a regular schedule and provides him the ability to have all the children, not just one per night over the weeks, which is very disruptive to the children's school schedule and very difficult for him to have one-on-one time with 1 or 2 children at a time and leave the rest at home. That's not the way parenting should happen. I know that he has limitations at his home, but he has had very rare overnight visits and mostly just the younger 2 at this point. So, excuse me. My client is asking that he also complete anger management and DB assessments, allowing collateral contact for my client to recount any history or anything relevant, and to complete any recommendations. The decision-making should also be limited to my client, given the history of abusive conduct, domestic violence, child abuse, and abusive conflict, basically involving the children in conflict in decision-making regarding visitation and things related to finances, including telling children that mom's in charge of their weekly allowances now, once he has provided her minimal amounts to support herself and the children in the last few months. We're asking that transportation be provided at each parent's home, the parent to remain in their car during pickups, and no communication during the exchanges. So even though we are asking for a restraining order, we are allowing continuing visitation, or the visitation transportation can be arranged by the third party, which is normally done. But at this point, we don't have any agreements, or we haven't had any discussion about that supervision provision if the court's going to provide it. For financial matters, my client is asking for spousal support. This is a long-term marriage, not over 30 years, but 24 years is very long. And having that my client has not had any gainful employment for a decade, with being the homemaker and caregiver for the children at husband's request, and the minimal work that has been done has been nominal at best. The requirement that my client work at home provides almost no ability to provide any substantial income, and especially with 2 young children under the age of 5, it would be nearly impossible to find any employment that would more than compensate for the cost of daycare if she were to find employment outside of the home. So we did impute my client at 0 because she hasn't had any substantial income or employment for child support purposes. My client's asked for $5,000 for spousal support because Mr. Ellis states in his pleadings he's provided at least $4,600 per month plus extras from joint accounts, etc. So in his statement, he's acknowledged that he's providing at least $4,600 per month to my client. So $5,000 is appropriate given the expenses and needs for the household. You can look also at the financial declarations of both parties. My client has budgeted $6,200 in her financial declaration for her and the children's household expenses. Mr. provided his financial declaration showing a household budget of $5,000. So the $5,000 is not unreasonable for the household expenses and costs. And Mr. Ellis has provided his financial declaration based on having the children half of the time, and what he presumes the expenses would be, because it's not his actual expenses. Court can also look at all the sealed financial documents provided, showing a clear accounting of funds that are available. It also, in addition to the financial source documents my client provided, show the transfer and multiple accounts that Mr. Ellis has control over. I'm not concerned about the retirement accounts and so forth, but it does show several bank accounts with money available in them that are in his control, including the bank account he removed the $27,000 from the joint bank account into. My client is asking for half of that to be awarded to her. Those were joint funds that need to be separated so that she has access and use of those funds as well. Let's see. And then for child support, depending on what the court determines as far as imputing my client to an income or not, given her history of non-employment, if the court orders a $5,000 spousal support award, his child support award would be $876, and would still leave him with about $1,500 per month. Given that he's in a home, we don't know what his expenses are for living there, if he's paying any rent, utilities, or anything. That will more than supply for the needs of the household, for my client to pay all the household utilities, the mortgage, and all the other expenses that are necessary for her to remain in the household. Otherwise, if we had provided the option if he will pay all those household bills and expenses, we can reduce that amount. But the concern is that there may not be payments made if given the choice of providing payment. So we are asking for the spousal support so my client can control that those mortgage and utilities are paid and not shut off. Mr. Ellis also provides a child support calculation, and in his declaration there attached, he provides that in a normal situation where my client has zero income, which he acknowledges, and based on his income, his child support obligation would be at least $24.50 per month. And with my client imputed at minimum wage, he would be paying at least $2,183 per month. So given those expenses, the court can either award spousal support and child support or a family support amount that more than covers her expenses and necessities for the household without having Mr. Ellis control and limit her access to those finances. My client is asking for exclusive use of the property. There has been some accounts in her declarations and more recently just unwanted contact at the household. Mr. Ellis has requested in his materials to be allowed to have continued access to the outbuilding, but that hasn't been what has happened historically. And even as recent as this weekend, which is not in the pleadings, there's been unwanted contact at the household that needs to stop. Honestly, there's no need for him to be there unnecessarily without reason or cause, unless it's a time for visit and pick up the children. And that's why we're asking for the exclusive use, that he stay away, and the restraining order. My client also wants to make sure that she has access to any of the household items. I think in her last declaration we provided, Mr. had either inadvertently or intentionally shut off the internet in the household. And it's incidents like that that my client is concerned about ongoing contact and access to the household. Most recently, I think there was a tractor that keys were required. So my client does want to make sure she has access to anything to use the property on the household that's needed. Property, I think there's no dispute. My client can keep the Dodge Caravan and property in her possession. Mr. Ellis only disputes her having control of the property in the outbuilding. As long as it's kept, undisturbed, there's no reason for him to need to be there and have access to that. And neither party should transfer any property or remove any property from the household. Let's see, as far as debt, I don't think that was addressed by either party. The household expenses, the court will either order spousal support or have Mr. pay those expenses. All the other standard language, not changing insurance, each pay their own expenses, should be approved by the court. My client is asking for $8,000 in attorney's fees. It's actually cost her more than that to come to court at this point. And the court, we're also asking for a JL to be appointed because of the concerns of contact with the children and the concerns of the abusive behavior. It would be important to have an investigation done. My client obviously doesn't have the funds to pay for that, but is asking that one be appointed either at court expense or at Mr. Ellis's expense, since he was the primary wage earner. And I believe that covers everything, Your Honor.
As you read, obviously, we respectfully disagree with many of the allegations and other issues. As background for the court, this is a case that a little different than many we see, at least on these dockets. The parties voluntarily separated. The parties voluntarily moved into separate living environments, or kind of involved. John has continued to support the family voluntarily this whole time. The separation of the parties seem to agree with that was October of 2022. When he moved into the shop building that has an office in it on the property. He eventually moved off the property, my understanding is the end of December. So the parties have essentially been separated 6 months, or well, I guess at this point, almost more than that, 7 months now at this point. Again, he's continued to support the entire family. The family has traditionally lived a very frugal life that allowed them to make it on one income. They are both devoted church people, and that was important to them that they do what they can, if possible, to live frugally and put money in savings and whatnot. Thankfully, they were able to do that. Mrs. did work out of the home occasionally. We don't dispute that John was the primary wage earner, but we do dispute that she doesn't have the ability to work moving forward. John, as we explained in this situation, is continuing to pay all these expenses and bills because he was hoping to reconcile. They worked with preachers trying to work through that. And, some part of him, I guess, is still hopeful that will be the case someday. But for now, we're in this situation where we need to deal with these issues. Thankfully, the savings that the parties were able to, accumulate over the years allowed Mrs. to spend $20,000 in attorney's fees to 2 different firms. She first hired a first attorney based on the bank statements in December of 2022. We don't know exactly what happened to that money or why that attorney anything or exactly the details on that. It appears she then spent another $8,000 of the joint account for Miss Green's firm, and has since spent some additional money, approximately $3,000 more from the joint account. So we have about $20,000 in attorney's fees she's removed since December from the joint accounts. That's apart and separate from the money that John's been paying her every month, as well as paying the house payment. From what was left in these savings, he's paid my firm $8,000 to match what Miss Green's firm was paid. He's paid the taxes for the entire year, as well as insurance, because those charges are separate from the mortgage statement. It's a situation where the family has always lived this frugal life, and Mrs. now is attempting to try and sell the court on a much higher standard of living and these much higher expenses than the family lived on when they were together. It is a situation where John makes good money, but it's not exhaustive. As we explained to you, he makes around $8,600 gross. The nets, if you count potential taxes and whatnot, is quite a bit off of that. The family historically hasn't paid much tax because they have 5 children and they're married, but that's going to change now. They're going to be living in separate households regarding various deductions and whatnot. John doesn't contest that he should have to pay some sort of spousal support to his wife and continue to do that for some period. But he believes it should be fair and equitable, fair and reasonable, based on true need and the ability to pay. Excuse me. Using possible tax figures from the child support worksheet programs, we estimated John's net around $6,500 to $6,600 net. That's the money that's available for the family, right? For everyone, including John and whatnot. And so we believe Mrs. should be imputed at 30 or 35 hours per week, a minimum wage. Obviously, she has young children, and that is an issue. But it can't be a situation where she's already been separated for 7 months. And we don't know what, if any, action she's taken to try and at least supplement income, whether that's full-time or whatnot, but it can't last that way forever. And we would believe the court should impute to her whether she's actually has a job or not. Regarding her need, it is a bit of a variable situation. Original declaration on when she was pro se was, she said she needed $54.30 per month was her expenses. The one she submitted to council, the second one, she said she needed $62.08 for monthly expenses to meet her needs. Quick look of that. I won't pick this apart forever, but the first one, the $467 on her financial declaration for taxes and insurance, that's already been paid through the entire year and probably into early next year. So that isn't a need that she's going to have, at least in the short term. She lists a total of $500 for things like vacation and home repair, the vehicle maintenance. Yet she also lists a gas and vehicle maintenance at $350 under that section. Yet she's not working. Obviously, she has to take the kids places and whatnot, but there's some question of whether that's a double dip or not. If you just subtract those big obvious ones, the child expenses. Now, obviously, she has child expenses. Those are real expenses. I think traditionally the court has kind of balanced that with, yes, but child support is supposed to pay for those diapers and children's clothes as well. To give her money on the maintenance side and the child support side is a bit of a dipping situation. If you just add those 3 big numbers, 467, 500, and the 590, that's 1557. So her need, based on her most recent declaration with the increased numbers, is 4651. That's not picking apart anything else in the situation. So while we have a long-term marriage, and my client has been the primary, bread earner or wage earner rather, maybe, traditionally the courts in a long-term marriage kind of tend to equalize the income or something to that effect. We can't give one party the lion's share of it and starve the other one out. Here, equalized, if he nets someone around 65, 6,600, that's about 3,300 to Mrs. Ellis. And then you figure out child support from there, for example. That may be one approach that the court tries to do. But to ask for 5,000, which is not even close to equalization, plus child support, essentially eliminates all available money. That is based on their most recent child support situation. That leaves John with I believe, less than $1,000. John has been kind of living with a friend from church. He's been paying him $300 and some a month or so to rent this room, all with the idea that he's going to continue to work with the church leaders and work on marriage counseling and whatnot. Obviously, that has not been successful thus far. He needs to be able to get his own place. He needs to be able to have the children overnight. He needs to be able to meet his own expenses. There's just not enough money to go around if you follow Mrs. Ellis's request. Mrs. Ellis describes how she's afraid to use the joint accounts. Yet the financials we provided shows her that not only is she receiving the money every month, every week, $500 and some every week from John, but she continually uses those joint accounts for all kinds of things, Targets, coffee, whatever, restaurants, McDonald's, whatever. So I don't see why she's afraid to use those accounts or where she states she's fearful. But those accounts, unfortunately, have been exhausted. Between the monies John's been paying her and she's been using from the joint accounts, including the $20,000 she made her attorney's fees, she's received more money than he's made during that same time period. Thankfully, for the savings, they've stayed afloat. John reports that if I wrote it down correctly here, there's about $10,000 left in one account. The joint account he thought was more, but she took $2,000 last week for attorney's fees, so it was about $3,000 or so in that account. That's it. The savings have been exhausted, we believe largely by Mrs. Ellis. Through agreement of the parties, they work together. They've been trying to do this. Similarly, this is, Mrs. is asking for a TRO in this case. That's going to directly affect John's job. He is a computer, I forget the exact word, IT professional, let's use that. He has security clearances through various school districts and governmental agencies. He quickly gave me a couple of examples like North Clackamas School District, Beaverton School District, Hillsborough School District. A domestic violence restraining order, which is what's being requested, is going to directly affect that and other security clearances he doesn't even know the extent of that his employer just submits him for. And so that's going to essentially restrict his employment significantly, and there's going to be far less money available. If there's concerns about John coming to the house, although he denies there's been any issues or incidences this entire 7 months of separation, the court can easily say, Mrs. Ellis is awarded the house. It doesn't have to enter a restraining order, domestic violence restraining order. He would like access to the shop. By agreement of the parties, he lived there for 7 months at the beginning of the 7 months. But to award her the house would alleviate that problem. It's a similar situation with the parenting plan, where actions speak louder than words. For the 7 months or 6 months before she filed her motion, in her own material, she never asked for a TRO. She didn't ask for supervised visits. In her motion when she was pro se, I understand that has now been requested through counsel, but as I mentioned earlier, she hired counsel for $9,000, previous counsel, in December, and so it's not a situation where she didn't have the money to protect herself or to do whatever she thought was necessary regarding restraining orders or supervised visits or whatnot. It's just now that after 6 months that she decides to ask for that. They've continued to exchange the children. John's been pretty hampered by this one room situation that he's living in with this elderly person from church. He has the kids quite frequently, all the kids except his oldest son. There's some disenchantment there between them and the breakup of the parents and whatnot, but they're working on that. And he believes the son has indicated to both of them that he wants to try and do some visits and whatnot. But he's had Carly and Rosabella, and especially the two youngest kids have always been there. Routinely, the two youngest kids are there typically multiple times a week. John and Mrs. Ellis have continually, communicated through text and whatnot. He provided me, of course, late today after we received our latest declaration, countless texts that show that communication if necessary, if the court wanted to see that. So they've been getting on. They've been doing this just fine. There's no reason for a TRO or supervised visits of that nature. The allegations she talks about are significantly old at best. Talks about when the children was 10. Well, the one is 15, I believe now. So that was 5 years old. John did explain to you and denied those situations, or they weren't exactly like Heidi wants to try and portray them. She mentions the chair or whatnot. That was the beginning of their marriage. And he disputes exactly how that went. But the end result is none of these have occurred for several years. The parties engaged in unsupervised visits and whatnot the last 6 months. There's no reason for those significant restrictions. Mrs. Ellis, and when she was pro se, her proposed parenting plan that the court I'm sure has in front of it still proposed unsupervised visits every Wednesday and Friday from 6 to 8, and I believe it was every other Sunday for a good portion of the day. None of that was supervised or whatnot. And so it's just now that she's asking for that, but there's been no incidences of separation that she identifies specifically that I saw anyways, that would justify anything less than that. John is said, like I said, hampered by the living environment and his ability to transport the kids when he has just the work vehicle with 5 seats in it. So he's tried to spread out the visits rather than having them all go in at one time. We understand that his proposed parenting plan isn't a traditional one where the court typically would have the 5 kids go at once and whatnot. But for the reasons of the living environment and the transportation right this second, we're somewhat hampered. His proposed plan spreads them out a bit. The kids seem to prefer that and request that spread out versus all of them together at once. And so his proposed parenting plan lays that out for every child. Basically, it's a midweek visits as well as 1 full weekend, a 3-day weekend every month with each child. That was his proposed parenting plan when he was in pro se. He asked to continue that, but that's the basis of that. I understand it's not typical, but the situation is, it is what it is. So he's hopeful that the court won't give Mrs. Ellis his entire paycheck, and he has some money where he can actually rent his own place where he can have overnights with these older children. You can't have teenage boys and girls sleeping in the same bedroom and whatnot conveniently. You have to spread them out in this friend's house if that was going to try and be the case. He's hopeful to get his own place where he can have them overnight and believes they want to be there. Regarding the finances, lastly, Your Honor, and I'll conclude. I know you read most of this. Regarding attorney's fees, we don't believe there's any reason or basis for that. Presumably the court's going to award Mrs. Ellis some sort of maintenance. We hope that it's far less than they proposed, obviously, but through the parties' limited savings, she's already hired 2 different attorneys at the cost of $20,000 from the joint accounts. That's in addition to the money he was paying her. Like I stated, there's no big pot of gold left anymore, at least as far as the joint accounts. Mrs. Ellis reports in her financial declaration, the first one, when she was pro se, I believe she said there was 17,000 in liquid funds, 22,000 liquid funds in her first financial declaration. In her second financial declaration with counsel, she says there's 17,500 in liquid funds. That's presumably after she hired counsel, because counsel was filing that for her. So if that assumption is correct, and I'm sure we'll hear otherwise, or the different, clarification on that. The 20,000 she's already spent on attorney's fees isn't part of that 17,500 she still has left. And so she in fact actually has more money than John does, because he's been giving her a good portion of the paycheck and whatnot, paying the full house payment, all the stuff we described to you. So we're asking the court to set reasonable maintenance and set a reasonable child support amount, and providing him enough money to survive and to get his own place so that he can expand the parenting plan, have 5 children, hopefully all together, and have places to put them and whatnot. He did in his financial declaration put what he believed was a 3-bedroom home in the Woodland area, what that might look like someday. And so that's our request today, Your Honors, to provide equal, I can't talk today, it's been a long day, equalization of the income and whatnot, and a fair resolution regarding that, as well as continue to provide him unfettered access to the children and continued unsupervised visits and et cetera. So this internet issue, I missed one here. Internet issue, that was a situation where his employer's router was at the house. He disconnected it because he needed to return it. He's not living there any longer. Temporarily, because one wire wasn't hooked up. Mrs. contacted him within 10 minutes, was rehooked because he told her exactly which wires to connect, and just an inadvertent situation. It certainly wasn't a intentional thing. And if it was fixed within 10 minutes when she called him. So that is the conclusion, Your Honor. We appreciate your time and appreciate the long docket that we've had here.
So approximately $20,000 withdrawn by, is what the claim is, withdrawn by mom for attorneys. And then mom's complaint alleging 27,000 transferred from the joint account to an account of dad's. Do you agree that that's accurate?
Somewhat, Your Honor. Yes, the proof is, I don't think she denies she spent 9,000 McKinley, Irving, and then another 8,000 plus all the recent stuff, the 3,000 with Ms. Green's office. There was 27,000 removed from the account to pay family expenses, such as the 6,700, I believe it was, of the taxes and insurance for the family home. That's not included in the payment that we're due. So that money's already been paid for that. From that money, also, Mr. Paid 8,000 to my firm as an initial fee deposit, somewhere to Ms. Green's firm. And so that's where we are. So I think he, as I mentioned earlier, there's something around 10,000 in that, and the joint account has something around 3,300 in it. That's the extent of the money left that he has control of. Mrs. 17,500 in her financial declaration. I don't know where that money is.
Okay, so of the 27,000 withdrawn by him, there should be about 14 left. Is that
13? Yeah, something like that.
Okay.
And he's here if I'm stating that wrong. He says I'm stating it wrong.
I can help you with that if you'd like.
Okay, go ahead.
Yeah, of the 27, there's close to 10 left. There was also a $1,200 homeowner's insurance that was paid out of there. And the reason that I came up with the $27,000 amount is because at the time, Heidi had only spent the $9,000, not counting all the other charges. She'd only spent the $9,000 on attorney's fees. So I took 27 and moved it to another account, and I left 16, which is 27 minus 9, in the joint account, knowing that she was still accessing it. She also has her own individual account that she has money in.
Screen, you have any response? Anything you want to address?
Yes, Your Honor, just briefly. So I should have objected, but I do believe that there is a concern about the statement that Mr. Ellis just made about the money that was taken out of the account. The $27,000 that was taken out was, I don't think, comparable like he is stating for the $9,015 left, because the $15,000 was left in the account after the removal of the $27,000 was continued to be used by Mr. Ellis to pay my client's allotment of funds. There's several withdrawals on that account that were taken out that were not my clients. So I don't think that's an equitable division if that's what Mr. Ellis is trying to purport. Additionally, I would want to have proof of the other expenses. I have not seen anything in the records, and I apologize if I skipped it. There were over nearly 300 pages of financial records provided, but if they're disputing what my client provided at the beginning of my representation, is that there was a transfer of the funds to that separate account and no accounting for how those proceeds were left. So to our knowledge, the $27,000 was still in that separate account that Mr. Ellis has, unless he provides any new documentation. All the financials that were provided and re-provided to court today for this hearing are prior to my filing of my motion. They were filed when both parties were pro se. So we have no new information in the last month on the accounting that was just stated in court today and not in any of the pleadings. So I just want to clarify for the record that testimony is unconfirmed.
Okay.
The other two issues I would like to address is that there's a mention that my client wasn't afraid to use the joint account. She actually made a statement in her declaration that Mr. Ellis said that she was embezzling money when she used money from the daycare or the preschool business. And that's a pretty clear suggestion that if you take money out, there could be criminal implications. Making threats like that is pretty significant. So I am concerned that he's saying that there's a statement that she wasn't afraid to use the money. Additionally, it's not uncommon for survivors not to report their domestic violence and to minimize or try to produce something to avoid the amount of repercussions from acting in a way that their abuser would define as contrary to what they want. So my client stated that Mr. Ellis is always wanting the parties to be one-minded, which means his mind or no way. So given that they're using her pleadings that she filed when she was pro se versus when she had counsel, I don't think is a fair and accurate representation of what was appropriate or necessary. I think that the attorney filed pleadings are more representative of what's appropriate once there was some protection and not fear of reprisal, because she's going head on against her abuser in court, and having to address those in court in that fashion will minimize the things that you think are appropriate and safe, given the situation that's how you're going to have to deal with it in court by yourself. So I just want to bring those to the court's attention and allow you to make the decision that you're going to based on the information provided.
Your Honor, can I be briefly heard on that last issue in 1 minute?
No, it's okay. I'm not going to go down that rabbit hole today because I don't think I have enough information.
Okay, the next three names on the list are Heather Kale, Amy Turnbull, and Ann Height.
Ms. Green?
I'm not familiar with Heather Kale, so I'd ask to strike her, please.
Right. Mr. Davis?
Your Honor, I don't believe I've worked with either of the other two.
All right. Amy
So I
Turnbull.
would ask the court to appoint who they think is best for this particular issue.
All right. We'll go with the next on the list then, Ms. Turnbull. I think a guardian ad litem is appropriate in this case, and I think we want one to get started as quickly as possible. So we'll get Ms. Turnbull on board. I would like, and I guess this is to whomever is going to be drafting these orders, an interim review sooner, maybe a little sooner than normal. And so 6 to 8 weeks out versus, 3 to 4 months out. Plan as of right now, I'm gonna reserve on the 191s. I understand a lot of the concerns that are being raised here. I also I'm gonna at this point, until I hear more from a guardian ad litem, I'm gonna adopt the mom's proposed parenting plan with Wednesday, Friday, 2 hours every Wednesday, 2 hours every Friday, and every Sunday. And Ms. Green, did you indicate how many hours on Sunday?
I believe the schedule I think it was every other Sunday, and I believe it's set from after church, approximately 4 hours, I think it was. Let me go back and check this.
Okay, that's what I have.
Sunday, actually 9 a.m. to 6 p.m. So they do attend church, and so the intention was after church, the children go and then be with them after church until 6 p.m.
All right, so every other Sunday until 6 p.m. I don't know when. Hopefully the parties can work that out when church ends. I don't know if church is done after 9 a.m. I'm assuming. Okay. At this point, I'm not going to order any assessments or anger management. I'm going to reserve for the GAL. Same with decision making. I'm going to keep that joint at this point in time. Transportation from each other's homes, parties to stay in the vehicle, and then there would be a third party. So I am going to adopt that portion as of right now. So I understand Dad may see that as a little bit of a step back, but it'll be an opportunity to be with all the kids at once. This is a 24-year marriage. I'm not going to get too far in the weeds with the 27,000 removed and then the close to 20 removed from the other side. I don't know that that's necessarily indicative of somebody that's scared to utilize the money that is available to them. But I also understand that mom has been primary caretaker of the children for an extended period of time and can't immediately join the workforce, especially when we have 2 children under the age of 5 that don't even attend school at this point. And frankly, without knowing much of mom's background, whatever income she makes could be what daycare costs. And so I'm not gonna, again, I don't want to go too far in the weeds on that, but at this point, I think a family support amount is appropriate. So that will be kind of spousal support, child support combined into a family support amount. I have reviewed the numbers, the mortgage amount, and I would agree with Mr. Davis that some of those numbers overlap, and I don't want to say double dipping. That makes it sound like an intentional, act, but it's the way it's listed is probably frankly not phrased very well. Those forms have been the same for a long time. So I reviewed all that. I know the mortgage amount plus the general, I think the mortgage is $2,200 approximately. The property tax is claimed to have been paid for the year. So, and looking at just kind of running through the rest of the numbers here, and then knowing where Mr. Ellis falls, essentially because I think the child support worksheet provided by Mr. Davis shows his $87.24 a month minus that $5,000. He's with $23.97 a month. If we take another 800 and I have the number here somewhere, 876 off of that, then he's that's pretty close to not having a living wage. Granted, there are some savings, but ideally, I think the parties probably don't want to have to live off of savings moving forward. So taking all those things into consideration, the amount of children that there are and the amount of the cost of everything at this point, I'm going to order a total family support in the amount of $5,200. As for any restraining order, I think other than the pickup and drop off at the home for the 2 weekly visitations and 3 every other week visitations, I'm just going to ask that Mr. Ellis not go on the property without permission. And I know that Mr. Davis indicated, and Ms. Green, you didn't respond to it, and he indicated it was late kind of discovery information to him as well, that the parties have been able to text back and forth. I don't know if you agree with that, or if you're at this point wanting Family Wizard or some other type of app to be utilized moving forward, given that I'm not putting in anything other than a temporary family law order. I'm not doing the restraining order.
So I'd have to ask my client if she has a preference for our family wizard. I know that they have been texting, but my client, I'm sure, is concerned about any abusive behavior and conduct, and our family wizard is good to kind of restrain that, especially tone and things like that. And then as far as like access to the property, I think my client would prefer, you're saying the third party is going to be there, so there's a third party supervising, correct? Is that my understanding?
Yes. So yeah,
Okay.
I'm adopting basically mom's proposal for visitation at this point.
Okay.
Did you say supervised visitation?
Yes, but not professionally supervised. And that's just until we get our interim GAL report and I get some more information. All right. So, and in lieu of a restraining order, which I am not granting, I will order the parties to begin communicating via our family wizard. My hope would be visitations. Tomorrow's Wednesday, that we'd get a visitation starting tomorrow. I understand that it may be a tough scramble to get an agreed supervisor between today and tomorrow. So as soon as there's an agreed supervisor, but there shouldn't be, I would hope that no party unduly delay these visitations because of this supervisor issue. I'm not imposing any attorney's fees at this point in time. I'm going to reserve on that. It sounds like more of a sticky wicket than any of us may understand at this point. Clearly, both parties accessed funds to pay for attorneys from the joint accounts. Great. We're going to leave it there for now, and we can delve into that once we get further down the road.
I have a couple questions at least.
Sure.
So the supervised visits is an informal third-party supervisor. Are these going to be limited to where visits take place or something like that?
My hope would be that the parties can agree on who that is, and then that they all agree that they'll find an appropriate location for those to take place. So I'm not requiring it to be at a certain person's home. I would hope that they can do activities and do other things like that, but just with a supervisor.
And then regarding transportation, I was trying to write as fast as I could, and I missed the decision-making part. So I know you said joint decision-making, but transportation, I didn't hear that. Is that a picking up parent situation?
And I guess I didn't hear, I know that Miss Green requests that the, pickups and drop-offs be at the home. I don't know if there's a request for whoever, if it's his visitation that he picks up and drops off, or if you want to split that.
I think I guess my biggest concern, Your Honor, besides that, I'm sorry, is that if he's going to be providing either one of those legs and all 5 children are going at once, then transportation, how it's going to work since he has a 5-seat car. So I'm just trying to think through this. Would it be that he can use the family station or the family minivan for the 2 hours in the Sunday afternoon situation? Normally I'd say, well, let's trade cars, but this is an employer car. She can't drive it. Right. And so that kind of limits our situation because of 5 kids. That's one too many.
Miss Green, do you have a?
Mr. Ellis, I think, has a suggestion, maybe.
Actually, I have a question.
I'm going to talk to Miss Green. Okay.
Yes.
Do you have a response to that concern?
I am concerned about switching vehicles. I don't want to put any undue burden or leave my client without access to a vehicle in case of any situation. I know that these visits are for a matter of hours, but I don't want to cause any more conflict and issues between the parties. What my suggestion would be is if he's having supervised visitation, then he should be able to have another person with another vehicle. I understand that they're not going to be able to supervise all the children in the car, but there is with father for the pickups and drop-offs. But my concern is that already the oldest child is not wanting to have contact with father. And so I do want to bring that to the court's attention. If it is going to be all the children visiting, that we are going to require the oldest child to participate and make sure we address, that there's no cancellations by father, that this schedule is going to be followed.
Okay. So, that does throw kind of another wrench into things a little bit with, the supervisor. I'm not changing that decision. My hope then would be that whomever's willing to be a neutral third-party supervisor that both parties agree to is able to help transport those kids. I am going to order that it's all children at this point. I haven't heard any reason whatsoever why 14-year-old doesn't want to be involved in these. There's some mention, and I know Mr. Ellis indicated he wasn't trying to force that issue. At this point, this is a court order. I would ask that the parties abide by that. If there is some and abide by the schedule that's being set until otherwise addressed by the court. If for some reason we get to a situation where Mr. Ellis and the third party show up to the house and 14-year-old is unwilling, we'll address that hurdle when we come to it. I would ask that the parties address it as adults and realize that all of this is impacting the kids in different ways, and they're going to probably react in ways because of everything that's happening. I frankly haven't heard enough information to just say, oh, 14-year-old's exempt. This is all the kids together to go see their father. If there's issues that arise, I'm happy to revisit that. But at this point, I think it's appropriate that all the kids are involved in this visitation.
I hate to belabor this, but I don't want this to be delayed for visitation starting. Regarding the transportation, I don't think you said who picks up or drops off. It'd be helpful if Mrs. can do one leg of that. But additionally, regarding the supervisor, if the parties were going to go to wherever, either back to his house or to the mall or wherever they decide they do other afternoons, can some children ride with father and some ride with the supervisor? Because again, you're putting if they all have to be with the supervisor and not with father, it's 5 kids have to be accounted for no matter which kind of car you figure out, is my point. So
yeah,
it's an unusual situation, not running too much, but
I don't want to, the parties have to rent an 18-passenger van to get everyone to where they're going. Part of this, I'd like to put on the parties to try to work out. If mom's willing, since she has the vehicle that's able, okay, dad says Wednesday, okay, I'd like to be at the bowling alley. Mom takes him to the bowling alley and he's there with dad and supervisor. And if mom can pick up, the more mom can do to facilitate that, I think is great. If they have a supervisor that has a vehicle that can transport, or they can caravan between dad's vehicle and supervised vehicle, and some kids are in each, I am okay with that.
So I believe what's happened is father's generally picked up and mother has picked up the children at the end of the visits. So I would say that would be the standard, unless there is some agreement that like she can pick them up and drop them off somewhere particular. So I just don't want it to be the burden on my client to have to support all the exchanges.
I think that's fair. So we'll assume dad will figure out the pickup and mom will pick up, meaning at the beginning of visitation, and mom will pick up at the end of visitation. However, that does not work together if mom's able to do both, and they agree to that, that's fine. Okay, so I'll order that Mr. Ellis make his regular payment for the last week of April, which is next week. And then the family support amount start May 1st.
Did you say May 9th is the return date? I didn't hear that, but I think Ms. Green just mentioned that.
That is the next available docket date. Ms. Wade, we still have room on that date. All right, I'll have a Ms. Green, since we're essentially adopting the parenting plan that Ms. Green provided already. I'd ask that Ms. Green just finish the other couple of orders.
And the guardian ad litem costs, how will those be paid, court or Mr. Ellis?
Given that we didn't do the standard, I'm gonna set it at 50-50 now, and then we can reserve if there's moving on.
I have a question about is, so can my client, which I know there's a protection to removing any funds from the account, is my client able to remove the funds from the joint account that had been left for her into a separate account without Mr. Ellis having access to remove those funds? So we can separate them financially and deal with the rest at a later date.
I object to that, Your Honor. They've been so mixed and she's taken so much out. I mean, we'd have to do an accounting if we're going to talk about dividing what, originally was community funds. We'd have to figure out what amounts those are and whatnot. I mean, we can try and figure that out to see what is even left, much less, and who's taken what. I guess maybe it's a better idea, is a better accounting. I know you didn't want to get in the weeds on that, but if we're going to distribute that.
I don't know that I have sufficient information to do that at this point in time, but clearly both parties have accessed significant chunks of the joint account to do a variety of different things. I'm not saying anything good, bad, or otherwise about that, but I think there should be protection of the joint funds as possible moving forward. If there's for that and you can itemize what's going on, I'm happy to reconsider that at a later date.
The client has a question if the court would indulge.
I don't usually.
I know.
Represented. I don't know if you want to.
I don't know what it is, Your Honor, so I can't.
All right, go ahead, Mr. Ellis. 1 minute.
Yeah, I'm not making a statement. I'm asking a question. The $5,200, do I pay that in one lump sum or do I keep doing weekly payments like I've been doing? How would you like that?
Ms. Green, does your client have a preference?
Well, I think that there's a mortgage to be paid timely. I'm assuming it would be around the 5th of the month. So we'd need at least the bulk of the payment to cover the house expenses. I don't know if,
How about this? Well, how about we do half by the 5th of the month? And the other half by the 16th of the month. That way it's just 2 payments a month of about $2,600.
Can I make another offer? And that is that I just go ahead and make the May 1st mortgage payment and subtract that from the 5,200. And that way she's got 30 days to get it changed over to her name.
No, but I appreciate it. Thank you. All right. Anything else?
I'm sure there is, Your Honor, as usual, but
Yeah. Well, we'll be back on the 9th at 1. So if there's any issues we need to clean up. Additionally, I also have presentations Friday mornings at 8:45. So if the parties see another issue that you need to resolve before we get the orders entered, you can always note it up for a Friday at 8:45.